Under compelling circumstances, my lord, I am mentioning a matter. Thrice I mentioned citing the urgency. Difficulty is, my lord, 31st July is the date.
Please mention on Wednesday. Yes.
May I,
31st July is the date fixed for completion of.
may I pray for my leave to file without certified copy of the
What
law?
is the urgency?
Urgency means 29th is the date fixed for appearance for CEO of board. Personal appearance for evidence, although we are not a party to the suit. Our application for order 1 rule 10, 710 are pending, keeping the lordship.
Your Lordship,
Grateful,
I'm
lordship.
permitted to mention one matter for non-prosecution running in the Delhi list, item number 360.
Non-prosecution.
Yes, Your Lordship.
Item number
360.
366.
360.
360. You are for the petitioner.
Yes, Your Lordship.
Do you have your written instructions with you?
Your Lordship, I have instructed the matter has been settled between the parties by executing our settlement agreement.
360 টা কালকে সোমবার দিন তুমি মেনশন দিতে।
Grateful, Your Lordship.
Yes.
For extension of interest.
But may I have the liberty to mention, my lord, at the time of rising, my lord, yesterday I mentioned serial number 23, but it was adjourned because none of the parties were appearing, my lord. But it is not appearing in the list today, my lord. I was humbly praying, my lord, because there is some urgency which is involved, my lord.
Yes, call the list.
Item number 1.
ফাইলটা দিন। This matter was
An application. Government was directed to carry out the amendment.
yes, carry out the amendment.
Time was not subsequent, that was not left.
That the department was directed to carry out. এটা করে দিন। The time to carry out the necessary amendments in the cost title of the civil division application is extended for a period of 2 weeks from this date.
We are due to some
So
inventory.
that is why I have website the wrong number, it has been uploaded.
Yes.
Because the cost title was wrong. That's why it has been uploaded in the wrong number. Yes, call the next one.
My lord, this is my application.
Yes.
And my lord, I have my father who has expired now on 24th May 2021. My father expired. I have filed an eviction suit in the 4th Junior Division, Alipur, Judges Court, Alipur. My father expired on 24th May 2021. On 26th of November 2021, I have filed substitution petition. That substitution petition was rejected by the learned trial court. May I read the order, your lordship?
Order dated 26th of July.
Order dated 26th of July 2024.
Yes. Where is the substitution application?
Page number 8, Annexure A. In schedule, my lord will take the page number 10 of the Annexure A, where by
So
mistake,
in the substitution application, how could you amend it?
this was the mistake.
Yes.
May I submit, your lordship? This was the mistake on the part of learned advocate Bajrang Manot. But in my respectful submission, trial court could have ignored those paragraphs, and because the substitution petition should be taken liberally by the court.
This application under Article cost title. ইসতে ওইটা থেকেই বোধহয় তাহলে ওরা বোধহয় এইতে ভুল লিখে Mr. Banerjee, please, you know,
Yes.
please ask him to come.
It's a Devashish code, my lord.
Yes, please see the
I shall-
mobile
I
number.
shall immediately intimate him.
Please ask him to come, pass over. Yes, call the next matter. Yes, what's the mistake?
My lord, the advocate Mr. Shubhankar Nag has written a Shubhankar Nag. I did not mention it is so.
Not appearing at my
It's not appearing on our.
I don't find it.
Telling the file কি হচ্ছে? Order sheet, it is 11th of July, এটা কি বলতে চাইছে?
There was a direction to amend the cost title, Board of Trustees for the Port of Kolkata. Maybe that one needs to be correct.
এটা লিখতে correct name of your client. Please write
My
it
lord, it
down.
has been corrected, my lord, in the cost
Correct.
title. It has been corrected.
Corrected?
Yes, my lord. Shama Prasad.
Oh, Shama Prasad Mukherjee, Port Kolkata. It has been pointed.
Item number 5.
My lord, in item number 5, Mr. Amitav Ghosh is appearing for the opposite party. My lord, he is on his way, my lord, asking, praying for a short passover, my lord.
My lord, it was regarding that occupational charges, my lord. Your lordship directed me to serve copy. It was fixed, my lord, at 3,000 rupees, my lord, without any subjective assessment. That was my only prayer, my lord. My lord, your lordship's own judgment is there. That was-
Judgment.
yes, my lord, my lord, I have with me. My lord,
What are
this is the
occupational charges need not be paid.
No, I'm not saying so, my lord. I have never said so, my lord, on the last occasion. But it kindly comes to the my lord, order impugned. My lord, why I have come before your lordship?
Pass over because his senior is coming.
My lord, pass over.
Next.
Item number
Yes.
6.
6, madam, for the petition. This is for extension of interim order. And I'm filing my affidavit of service. Dada. Good.
Yes, madam.
My lord,
What is there in the civil revision application?
that civil revision application.
If a witness dies, the legal heirs can be recalled as a witness.
No, my lord, at that time, the
That has been
earlier
rejected.
witness, my lord, he deposed his evidence, my lord.
Yes.
But that document, it was not exhibited.
That person
was not-
expired.
Yes, the
Yes,
father of the
person
petitioner,
expired.
yes.
So where is the provision that the legal heirs can be recalled? Show me.
My lord,
A witness dies, after that the legal heir will be recalled as a witness. Where is the provision?
my lord, order 18, rule 17, my lord.
Yes.
My lord, the order 18, rule 17.
Order 18, rule 17 is the court's requirement, madam.
Yes, my lord.
So its court does not require
But
recalling.
it was not it was not marked exhibited. My lord.
It
The
does not
document
require.
already
Order
tells that.
18, rule 17 is the court's requirement.
And the
Please place order 18, rule 17.
yes, my lord.
It's
Court
power of,
recall and examine witness.
yes, the court may at any stage recall a witness who has been examined. Who has been examined.
Yes.
So this particular person has not been examined, the legal heirs of PW1. PW1 is no more.
Yes,
Wherefrom he will recall him.
it is only the document is only it is a RTI
Maybe
application.
whatever it
My lord.
might be, cannot be recalled.
My lord, initially this secondary evidence, my lord, the some documents.
Whatever primary, secondary, whatever
My lord,
document,
only the RTI evidence that the original
legal heirs
document.
cannot be recalled. Recalling is
And only that much, my lord. Only that
Madam,
much. That
there is no provision. A person, anything
yes, the
more?
proposition the court may think fit, my lord.
Apart from that, order 18, rule 17 may not be applicable. Section 151 is there. I'm not on that. But the person who has not deposed, how can he be recalled?
My lord, but he is
This
very much
application
in
under-
knowledge with the document, my lord, because it is an RTI document.
There are other
Received from
procedures.
the government.
There are other
authority.
procedures invoke that.
My lord, only that part is needed, my lord. It is a government document where the government stated that he is the
Are you
original.
ready with the main matter today? Or you want time?
My lord.
Are you ready with the main matter today or you want time? Because this is appearing for the extension of entry order.
Yes, my lord.
I want
Kindly-
to
yes,
take up the main matter. You are ready today?
no.
Tomorrow?
My
Monday?
lord, kindly extend the time.
No. No necessity to extend. I will dispose of in the next day.
Then, my lord, I'm ready to. I'm ready with the
Today?
main. Yes.
All right. When the entry order has expired,
It will expire on 31st of this month.
yes, 31st is
Then, my lord, kindly fix it on Wednesday, my lord,
why?
because Monday and Tuesday I have some personal difficulty. I may not come to court.
Wednesday, 30th.
30th. Because 31st is the last date.
List is on the prayer of the learned advocate for the petition. Every service filed in court today is taken on record. Yes, call the next matter.
Number 7.
Yes, Mr. Rai.
This is a visual service. Yesterday, when this matter was taken up for consideration, you also intimated the clerk of the learned advocate. The matter is fixed today. These are the two documents. But what happened was at the stage of argument, a legal heirs who have been substituted in the place of the original defendant asked for recalling of PW1 for adducing evidence.
I could not follow. At the stage of
Argument.
what happened?
Substituted heirs of the defendant number 4, who originally
Substitution was effected earlier or
no,
substitution
effected
after
at that point of time.
Yes, thereafter
Thereafter, he filed a
going for the opposite party.
Lordship, opposite party number 4. Lordship, I'm appearing on.
4.
yes, he is the
Lordship, I don't
Yes.
have the brief.
she is the only
Not here with me, and my senior advocate is on. The advocate who is leading me is on other court.
in violation of the order of injunction, property was transferred. I filed an application for
When he will come?
Lordship is engaged in court number 36. It would take some time, Lordship.
12 noon?
12.
12. Border Swan. ওই 12টা 5 রেখে দেন। Yes. 5 minutes after 12. Yes, next.
Item number 8.
8 minute down for the petition. This is the expeditious disposal of matrimonial suit. 2021, the husband preferred the suit under section 13 of the Hindu Marriage Act. Section 24 application already disposed of.
Alimony is being paid.
Yes, my lord. My lord, kindly come to the last page of the order in P. Before started evidence of the husband, my lord, he has already deposited all the,
11th of August for evidence.
yes, my lord, evidence of the husband.
You are the husband.
Yes, my lord. 2021 suit.
This application under Article 227 of the Constitution.
Appearing on behalf of
Yes. Which item?
This item, my friend managed.
All right.
My lord, I am appearing on behalf of the petitioner, my lord, in this matter. It is expeditious disposal of the two application, my lord, because the injunction application and 151 application is pending, my lord,
151 for
for
police help.
police, my lord, because they have changed the nature and character of the property. They have tried to, my lord, they have not filed the objection, though they have appeared, defendant appeared on 4th March 2024.
This application under Article 227 of the Constitution of India is at the instance of
But I'm for the petition.
Then I am for
Yes.
the opposite
But
party.
Opposite party.
1 to 6.
against the order, Lord, rejecting 151, I came before Lordship.
Rejecting 151.
Yes. Lord,
What is the 151 for?
Lord, I am stay of further procedure of execution.
Why? On what ground?
Lord, I'm placing my case, Lord, then. Lord, your Lordship, Lord, kindly see the short facts, Lord. I am.
What is that?
Rather,
List of dates.
yes, Lord, short facts, Lord. Your Lordship, kindly see first, the total land is 10 decimals. Then,
Yes.
Lord, Kasinath Chaudhuri, 2.55 decimals. Horipada Chaudhuri, Lord, this is wrong, Lord.
Could not have been.
7.5 decimals. Lord, hurriedly done. 7.5 decimals.
7.5.
Yes.
Yes.
Now, Lord, your Lordship can see Horipada Chaudhuri, first 10th January 1950, sold out by a settlement 1.50 give me, and then rest 6 decimals, that is I am a tenant, overall the 6 decimals there are building is there, and your Lordship, then your Lordship kindly see the next Muchiram, 12th June to 1951.
What is your name?
My name is Chandrasekhar.
Chandrasekhar or Chandramohan?
Chandramohan Khandelwal. Chandramohan Khandelwal.
All right.
Now, dear Lordship, can see the Lord Muchiram Mahato and Suchiram Mahato, he purchased in the year 1951. Allegation is 8.5, but actually the Horipada is the 7.5 is the owner, but sold it 8.5 decimals. Now then the Muchiram Mahato.
What is
he
your
filed a
status in the
suit.
property?
Yes.
What is your status in the property? Who are you?
I am the owner of 1.5, and from
You are suffering a degree of eviction. You have suffered a degree of eviction.
yes, separating.
In respect, what is the suit property? Please show me the degree of eviction. Show me the degree of eviction.
Not 8.5.
Show me.
That is my main grievance.
What is your main grievance? You have not come to
I am
your main
telling.
grievance.
I am telling you.
So an eviction degree has passed against you.
Yes.
Affirmed up to
In
Supreme
nine,
Court.
No.
from
Everything affirmed.
1976
Section for
affirmed
up to
thereafter execution.
আমি বলে দিচ্ছি।
up to second
বলে
appeal
দিচ্ছি।
degree
আমি
affirmed.
বলে দিচ্ছি সবকিছু আমি বলে দিচ্ছি।
Because he is the petitioner.
Yes. Up to High Court,
Affirmed.
section
After
47,
degree-
everything is completed. But everything
47 also complete.
47 also completed.
What is left now?
Left now, why I am telling. But
No, what is
I am
left?
the
I'm asking
I
you.
am the owner.
And also
No, out of 10 decimals, I am the owner of 1.5 and 2.5. Everything. Out of 10 decimals.
Yes, when have you purchased?
But 10th January 1950.
You have purchased in 10th January 1950.
Yes, by a settlement. By a settlement I got. And they
1950.
purchased 1951. They filed a suit for eviction in the year
To take
1970.
this point in the eviction suit as defense, please show me.
Like eviction suit,
You have purchased in 1950.
1950, yes.
So the eviction suit was filed in.
1975.
So that was a valid defense in the eviction suit. Show me your defense in the eviction suit.
But I have not seen that type of objection. But
Can
no.
you raise it now then?
Yes, now. No.
Can
no,
you raise it now
no,
then?
Why I am filing? But I filed a suit, title suit number 62 of 2007 for declaration, partition, and injunction.
but I got injunction,
What is the
That-
stage of that suit?
but evidence will be started, not
All right, let that proceed. I can also expedite that. But in
yes,
the
no
meantime,
problem.
in the
But-
meantime, let the degree be executed. Let
But
this
then
degree
what-
be
then-
executed. I will also.
No, then Lord, my property, I am the owner of others, but not 8.5, he is the owner. Actually, he may be the owner of
You cannot take
fixed decimals.
that point is not available to you now after 47.
But
After the degree.
only thing, Lord,
Because you have suffered a
No,
degree
no.
in respect of
yes, but
8.5.
only thing is, Lord, I file a suit, partition, declaration, injunction.
Succeed in the
That-
suit, you will get back possession. Succeed in the suit, you will get back possession.
Lord, you kindly make it clear.
That's the law.
Yes, Lord, you kindly make
That's
it
the
clear.
law.
Yeah, Lord, you kindly make
Yes,
it.
Mr. Rai, what do you say?
Yes,
Yes, my lord.
Lord, you kindly make it clear.
It's not the law, Mr. Bhattacharya.
Oh, your lordship knows. But the only thing, Lord, injunction I got, both the parties will maintain status quo in respect of the properties question. And appeal court, they file appeal. But that was dismissed. So, Lord, now, Lord, in my
Sir,
in my
status quo
portion,
is there.
in my portion,
Status quo is
Status
in
quo
operation.
without saying that who is in
But Mr.
position, not,
You are a party in that suit.
yes, yes.
So,
Now,
what is
my
that
lord,
order of
your lordship kindly see,
now,
please
my lord,
see
the court has, if your lordship kindly see the order impugned, the court has discussed in length
All right,
about
that is the
the-
order of status
lordship
quo.
kindly page 38.
38.
Yes. Ordering portion, your lordship. That's
So both parties are directed to maintain status quo.
yes.
All right, fight it out there. Who is
Till the
in possession? Fight it out there.
Then, Lord, your lordship kindly make it clear.
What? Make it clear.
So that, Lord, I should not be, Lord.
There's no order of injunction. Order of status quo. Whoever is in
Yes,
possession.
but
is
Lord,
in possession.
I am in possession since 1975, Lord. Since purchase, not 75, since 50. Since 50, I am in possession.
Uh,
Now, my lord, the-
immediately, you have filed a suit for his eviction. So possession is admitted by you in
Yes.
respect of the suit property. Now, there is, in respect of that same property, there is an order of status quo.
now, my
With
lord,
regard to possession,
now, my lord, three,
you
my lord,
cannot
three
dispute
owners,
possession
my
because
lord, three owners filed a suit for eviction. Now, my lord,
three owners.
three owners. Now, my lord, one of the owners, my lord, transferred his share to Mr. Bhattacharya's client. My lord, as per his claim, as per his claim. Now, my lord, he contested the suit, the eviction suit. The eviction suit is affirmed up to this honorable
In
court.
the eviction suit, he took this defense that he has become the owner because he says that he has purchased in 1950.
Yes.
How can it be?
No, my lord, that defense he has not, my lord, specifically taken. He said that he has.
When did he purchase?
1950.
He says in 1950.
But the suit is subsequent. So how
Subsequent.
could the three owners, if one of the owners have transferred, how could the three
No, my lord,
owners?
that's the property which is not, my lord, involved in this suit. The tenanted portion is a separate thing altogether.
Show me the schedule of the eviction suit
Schedule of the eviction suit.
or the decree in the eviction.
That
suit,
is,
whatever
I
it is.
have not handed over.
Given.
Yes,
This is the decree.
handed over. 8.5. Last portion, your lordship. Stating.
No, eight decimal.
No, 8.5.
Oh, sorry.
8.5.
So this is the decree for eviction. What is the effect, Mr. Rai, if he has become claims
Now, my
to
lord,
be
my lord,
purchased on one of the
the Indian umbrella is staring at his face. Now, my lord, not only that, my lord, another decision is also stated in the justice.
merger?
Merger. My lord, until unless the whole of the property is March, she has no defense.
There is also a decision passed by Justice Dotto.
Yes, that
You
is
got
also
that?
there. No,
Maharani Chakraborty also.
that in the subsequent decision of 2005 of the Honorable Apex Court. আরে সেগুলো তো আগে দিতে হবে, বললে পরে হবে না।
Anything?
Only thing, blood, I should not be disposed of my own property. That is my main submission.
But you
But
have to be dispossessed of the decretal property.
But it may be, but
On the
your
decretal
lordship,
property, whether it's
but
your
blood,
own
if
property
I,
or not.
blood, if I gave blood that property, blood, but this is not 8.5, he
Get
cannot
that property.
purchase.
Get that property, file an application for expeditious hearing of that suit. You will get that property soon.
No, my lord, I am a owner of that property.
Yes, yes.
That has not been decided by any court.
Yes, this
Still
application
now.
article Yes.
Like, I was not paying, I was not ready with the papers. May I come on Monday? No, application
Once
of,
you miss your chance, you miss your chance.
not application by tenant on the, for inspection of the premises.
Yes.
Eviction suit, I filed a petition for not inspection of the premises.
For what?
Not the building, there is a damage in the building. I wanted to repair the building. And for repairing lot, that inspection is necessary. Now, after passing the impugned order, learned judge has said no, not required, because there was an order of 144/11 of the KMC Act. Not after passing the impugned order, the KMC has passed an order that no, it requires repairing.
Where is that order of
Now, kindly see note this order after the impugned order passed. It is page 81.
Page 81, yes.
This is order passed by the KMC pursuant to the order passed on this honorable court in the writ petition. Kindly see the page 83, last paragraph. I have to place the entire order. It says note in the above circumstances, it's ordered that engineer building so and so is directed to repair, demolish, secure any such portion of this block in respect of.
Have you challenged this order?
No, this is received on the signed on 7th July, my lord.
Yes.
Kindly see the date of the order, signed on 10th of July.
10th of June.
July, my lord. Kindly see page 80.
80.
Signed on 10th July, and it was released thereafter.
All right. So,
No, the
10th of July. So,
And
have
the
you
order
challenged
impugned-
this order?
No. Order impugned in lord, letter 25th March.
Yes.
That is only I have to place the order of the KMC before your lordship for my lord's consideration.
That order is here.
The order of the learned judge, the impugned order is here.
Impugned order is here.
Is it here?
KMC's order is also here.
But not, I am not properly ready with the matter. My lord, just now I got
On the prayer of the learned advocate for the petitioner.
Monday.
Tomorrow.
Item number 12.
Will again come serially. Yes.
Now, the respondent, my lord, is the petitioner before your lordship, assailing, my lord, the quantum of the occupational charge imposed by, my lord, the trial, the appellate court in granting stay. My lord, shop room
Has to be
140.
granted, Mr. Kormakar.
But I'm against that, against the quantum. I'm for the landlord. Now, my lord, 142 square feet in Newmarket area, they have granted, my lord, only 12,000 rupees occupational.
12,000
Only.
Yeah.
on the lower side.
Exactly. That's exactly what I'm saying.
It's on the lower side.
That is exactly what I am saying.
You want to increase.
Yes. My lord, I did not make any further submission in that.
I was thinking that you are, but Mr. Kormakar, only thing is, what's the stage of the appeal?
Just has been admitted, stay has been granted.
I'm directing the appeal to be disposed of. Because otherwise it will be kept pending here.
It will not be kept pending. Your occupational charge can be kept pending, the appeal will proceed. I'm not asking for a
Then what's the use? Mr. Kormakar, you want the money. If you want the money, appeal has to be stayed.
There is
Because
no,
you want to see the color of money, Mr. Kormakar.
is there any requirement, may I ask this question to myself, is there any requirement for stay in a adjudication of
see the-
occupational charge?
Yes, because you are
Stay
agreed.
has been granted in the appeal, let it
Kormakar, you are
continue.
agreed by that.
I'm aggrieved by the quantum.
So you will lose the money. If in the meantime, the appeal is disposed of, you will lose a substantial sum of
No,
money.
I'm not.
Why?
I'm not losing out.
You will
I'm-
be losing.
No.
If the appeal is
I
disposed
will
of.
only get the benefit of the enhancement, nothing more than that. If I lose here, if I lose here, I will not get the enhancement. Whatever is
I'm
there is there,
expediting the
remains
appeal.
there.
What is the next date fixed? I'm
But next
expediting
date will not. কবে আছে? Next. No,
it. Or you can serve, they can come up with another civil division application for reduction. I will consider that.
they will not. They will
For
not.
reduction.
They will not. At least I'm entitled to 30,000. At least.
What materials you have produced?
Lord, the report is
Lord,
there.
trial
The
that-
valuation report is there.
Show me that.
And Lord, with the given idea of my Lord,
Not considered.
Lord,
Was
with
not
the
considered.
it was considered and then given 12,000. And that's also the rent.
Then where is the scope
That
of
is also the
interference
rent.
under
The
Article? Show me that. Show me that. Then there is no scope of interference under 226.
Lord, interference is my Lord's conscience.
Show me, show me.
my lord, interfere,
The
reason for
materials, I was under the impression that no document was produced.
my lord, documents, my document.
Show me
produced-
that portion, how it has been.
That kindly comes to the valuation report, page 58, kindly comes to at 64.
Detailed valuation report
Detailed. So
containing.
they say, my lord, I am entitled to 21,300.
Assessment by the valuer.
21,300.
What?
21,300. That's the assessed value. And that's also an orthodox rate of, my lord, valuation.
The valuation by one method has been done.
My lord, valuation by several
Methods are taken,
No,
the average of that. Show me that.
at least two methods I am seeing, my lord. One is government registered value, that's your lordship would find page 64. The other part is, my lord, the physical aspect, your lordship will kindly come at 62. Characteristic of site and the usual. So, my lord, two methods are already there. And the impugned order only proceeds on the basis this was the rent, so kindly pay this. As if I have come to claim rent.
Show me.
May I serve and come back?
Let me see first. To be satisfied, prima facie for certain. Let me see. Why are you hesitating to show that those findings?
This is the point.
How the report has been considered? Let me see.
That kindly comes to the internal page number 2 of the impugned order. Having regard to the age of the property being 70 to 80 years.
Was it considered by the age of the building, considered by the valuer? Show me that. Show me that
Yes,
how the valuation will be.
Lord, kindly comes to page 63.
Yes.
Year of construction, residual life, as informed. My lords kindly got it here. Lord.
Page 63.
63 here.
Yes.
Bottom. I mean, sorry, my lord, at the middle portion.
Yes.
Third, my lord, row of. As informed, the building is about 70 to 80 years old. Considered.
Where is the aspect of depreciation of a building? Because land appreciates, building depreciates. Show me that aspect of the valuer which has been considered.
যখন আমি টেনেন্টের হয়ে রিপ্রেজেন্ট করছিলাম তখন অ্যাডমিট করছিল তারিখ দিচ্ছিল
Show me the difference.
It's 64.
Value of the value has not changed appreciably. However, considering this amendment, it's the way to behave.
From the above, we assess the fair value of the captioned unit situated at such and such credence and recent trend in market. It is also worth mentioning that the value of asset capital has not changed appreciably in the last couple of years. However, considering in this mind, if we ascertain market value of area such and such, 20, it comes to 200. That's why, my lord, so orthodox rate. Today, my lord, I am entitled to 30,000 at least from in that area. 142 square feet in new market area. Fancy price. Lord, I would make this submission. There is no consideration. Perverse consideration is, Lord, a far chapter. There is no consideration, even of the practical value. My lord is Lord taking some time to assess. So, Lord, I must, Lord, serve or come back. I'm not asking for an interim order.
Interim order has to be given.
I'm not asking for an interim order also. Fatin, Lord, I am for the plaintiff petitioner.
But I am for
Only-
the opposite party caveat.
Lord, only one difficulty, Lord, the ad interim injunction which was made confirmed by the
The
Lord,
trial
trial
court's
judge.
order certified copy, I am told, my lord, it is not, my lord,
But,
appended to your, my lord's speech.
What?
Trial court certified copy.
Lord, I also find that's why, Lord, I
I'm
started
used to
submitting.
now.
Your
No, Lord,
Your lordship allows,
Now this is the practice now,
very,
which is being followed by Mr. Mukherjee.
no, I think, my lord, his chamber has not filed this.
Lord, that's why I started my submission saying that the difficulty is, Lord, the trial court, Lord, ad interim order is being confirmed by the, Lord, trial judge, and thereafter, Lord, the appeal preferred, appeal, Lord,
It's from ad interim.
no.
Contested.
Contested temporary allowed,
Oh,
ad interim made confirmed.
Ad interim made absolute.
Absolute, thereafter, Lord, the challenge thrown
This
before
is
the
against temporary injunction.
yes, against temporary injunction.
Appeal disposed of or
Appeal allowed.
yes, disposed of,
Disposed of.
not the
Difficulty on my part, Lord, I could not able to prepare myself because none of the document, either from my sides or from the side of, Lord, the defendants, appellant before the miscellaneous appeal, is being annexed with the revisional application. And, Lord, the detailed observation of the learned appellate court is on the basis of the document relied by the parties. Lord, kindly, Lord, gives me some time so that, Lord, I can come back and assist your lordship. Because this temporary injunction on merit without those documents, Lord, I cannot, Lord, assist your lordship. I must be candid. Lord,
I have
it's
the
my
document.
difficulty.
If my learned friend prays for time, I'll not be objecting. But, my lord,
I'm
here and
in-
now I can show, my lord, with the reference to what the learned appellate court has held, but he's not entitled to an injunction. I have a
show me the
registered
trial
lead in my
court order.
favor.
Show me the trial
I have a
court order.
registered lead
Trial
in my
court-
favor. And he is putting up his claim on the basis of an agreement.
Where is the plaint?
The plaint is not annexed.
Lord,
Injunction
I may
application
say
is
it's
annexed.
totally incomplete document. Lord.
Injunction application is here.
Yes.
Yes, where is the case made out by you? What is the dispute?
Lord, this is regarding physiculture of a pond. Lord, I believe, Lord, what from I gathered, Lord, from the judgment of both the courts, Lord, there are a Lord, dispute with regard to the who, Lord, the pro forma defendant is a deity represented by
Former defendant is the deity.
deity.
Yes.
So that respondent number 4, opposite party number 4. So, Lord, who will represent the deity? Because someone sometime will not have executed representing as deity of pro forma defendant number 4 in favor of the defendant one lease deed. I am also claiming through a deed, Lord, for 1 year. My physiculture right is for 1 year. Lord,
Not exceeding 1 year.
not exceeding 1 year.
So not a registered one.
363 days, according to him.
So not exceeding 1 year for unregistered document.
And Milord, there are, Milord, on the previous instance, there are other Milord, like this fashion, Milord, this particular arrangement, others have been also given. They also filed suit, Milord, there are other proceedings pending. Now, Milord, in the present conspectus, Milord, again the same dispute arose, Milord, Milord, defendants are claiming through by virtue of a deed executed, Milord, through a Milord, representative of the deity sometime in 80s for 99 years.
And you are
81
claiming from
I am also claiming through Milord that Milord, from Milord, the respondent number 4, pro forma respondent number 4,
which year?
present. Which is
From
from
which year?
2024 to 2025.
Only 1 year.
The plaintiff is claiming through defendant number 1. He doesn't have a privity of contract with the deities. Kindly have a look at their statement.
Defendant number 1. Who is
Paragraph
defendant
6.
number 1? Who is
Paragraph number 6. Defendant number 1 on temporary lease for the year 2018 to 19. Paragraph 6 at page 12. I'm sorry.
yes.
So the plaintiff claims to be an agreement holder for 363 days through the defendant number 1. I have a registered lease deed for 99 years.
So admittedly the pro forma defendant is the owner.
Yes, that is
Admitted by both the parties.
Both the parties.
This suit is not against the no relief has been claimed against the deity.
No.
And admittedly the pond belongs to the deity.
Lordship.
Yes.
And I have produced document to show, Lord, that I am doing the pisciculture, Lord, all the documents
what is the relief claim?
Lord, may I just go through those documents, Lord, and come back before
and
the
Lord, the relief is not restraining my client, Lord, not to catch officials.
Your case in the injunction application.
Yes, but Lord, there are other materials that has been placed before the learned appellate court.
That appellate court has dealt with. Lord, your lordship can go through that.
You have a copy of the plaint. Please give me the copy of the plaint.
সেবতী এটা পুরনো কাগজগুলো।
Alright, Mr. Mukherjee, you are not affected because.
I am, because I am doing the pisciculture
No, but
and they took
injunction,
an injunction.
no, injunction has been rejected.
Yes, Lord, if
So
that
now you
takes
are-
time, I am not Lord object.
From
I am not.
beginning, I
But
said.
prima facie, I say that whether Lord there at all Lord this should be entertained or not, that your lordship sees. Because if your lordship Lord says, Lord, this is not the.
According to you, the suit is not maintainable.
Indeed, and Lord, from the facts that appellate court said that considering the materials that my
Appellate court
client.
has said the suit is not maintainable.
No, that did not. It did not say that. The appellate court not went by the previous not the judgments. The judgments not concerning the defendant number 1 who according to the plaintiff got the lease from Lord the DTs. That suit Lord the injunction was not vacated. Once it is vacated, the plaintiff comes up and says that I am the agreement holder and files a suit. His case is based upon an agreement from the defendant number 1 who has lost in a previous suit.
Lost in
And
the
yes,
previous-
and I have produced all those documents in the appeal court. Appeal court has remarked that even in the order. The appeal court is very detailed in not considering why there should not be an order of injunction.
One, two, three.
Kindly see, Lord, the orders.
Numbers 1, 2, and 3.
I am appearing for 2 and 3, who are not the real defendant. One is the gentleman who took the lease according to the plaintiff.
And 2 and 3.
And the plaintiff is claiming through the defendant number 1 through an agreement for 363 days.
2 and 3.
My clients.
No.
They are
What
not
is
the
your-
original lessee of 1981 through the Shebayat of the DT.
Oh.
And that is a registered lease. I have produced all document to show Lord that I am buying Lord all the materials for pisciculture. And Lord, those are produced before the court by UEFA Firisti, Lord, the entire Firisti is with me. Considering the documents I have produced before Lord, the first appellate court was of the opinion that my case is more believable than the case of the plaintiff for a grant of injunction. So this is Lord, the long and short of the matter. And in my written objection, Lord, I have detailed about the previous, Lord.
What do you say? He wants time to.
But time, I at the outset said, Lord, time, I am not objecting.
But
so
my
far
Lord
as that
senior friend
English-
is doing, I don't know. Time, my Lord senior friend is not objecting. Really, Lord, I am.
But for Lord, if he asks for Lord, a
But
short
this-
order at the last stage, that's the reason.
No.
Order of injunction. No, I think that.
That is
This is the copy which has been handed over yesterday night. So I could not able to gather. My learned
We
friend,
got that because I was a caveat.
yes, but my learned senior friend is saying that he is having Milord all copies of exhibit list and everything. But my learned blood seniors, junior have assisted.
No,
him.
my client has been instructed to bring all those because
That's why I could not gather.
getting an order of
Otherwise,
injunction
Lord,
against
I-
my client will be difficult.
No, I have not pressed. Any day, Milord, subject to your lordship's convenience. Next week, apart from Milord Monday and Tuesday, Milord, those 2 days, Milord, I have difficult.
Wednesday, Thursday, to
No.
Friday. Till Friday, Thursday, Friday.
আর কোনো অসুবিধা নেই, আমার দুদিন
আমাদের next week
After a week
Lordship.
or Thursday. Thursday.
No, not Thursday. That Thursday I have some matter fixed.
Friday.
Friday I'm
Friday.
Great.
That the academic service be kept.
Every service taken on record. Mr. Mukherjee, I think you will be getting more documents from Mr. Mukherjee.
Yes, I already requested this doctor.
Because the bunch which he has taken from his junior.
This is Milord, our bunch. That is our Milord, the documents filed before the
Your document, not their document.
Then I will
This is
have
by
to-
PDC what we filed before the first appeal.
You do not have their copies. Why was that?
That's the difficult.
Because
Because the court, the appellate court recorded, both the the parties have relied upon bunches of
So
documents.
both of you, Mr. Mukherjee, I ask
Yes,
you,
yes,
both of
if
you-
I got that,
both of
I
you
will
can
exchange.
your
Yes, yes.
documents so
Whether
that
we can make
it
our
will be
certificate.
better. Otherwise, you will say that I don't have those documents.
Very well.
So both
we'll-
of you can exchange
we'll-
those documents.
But may I take back the copy of the plaint?
Yes, yes. Print diye din, print diye.
Photocopy.
Yes, call the next matter.
Item number 14. Well, I would petition on it.
Yes.
Well, suit was filed by the.
What do you want?
Challenge the order passed by the learned trial judge.
Order.
Well, order passed on. Order passed on 7th July 2025, allowing the opposite party plaintiff to recall the PW1. Well, 4 years, 4 or 5 years, PW1 were examined and cross-examined. He has answered everything. Now the plaintiff opposite party wanted to produce the document which was prior to filing of the suit. Well, kindly see this. I have annexed the application.
What is the document? What is the suit for?
Suit for declaration and injunctions. The certain constructions have
And
been.
where is the application under order 18 rule 17?
My lord, I have filed it. My lord, I have annexed it, page 83. And the documents annexed to the applications, that is much long prior to the filing of the suit. And during cross-examinations, PW1 answered the defendant number 1 has not made any construction except asbestos shed. Seventeenth report of hearing held on 17th October.
Mr. Ghosh, this document is necessary for the purpose of deciding this.
Well, this document is much long prior to this suit, and I PW1 cross-examined on this point, that whether defendant has made any constructions. Well, and kindly come to this page, evidence of PW1. Well, evidence of the PW1 22nd December 2016. That yes, nothing. Dependent on
Mr. Ghosh, this is a document issued by a municipality which is trying to produce. What are the evidence is there that is there? Let him produce, you will be having a right
that
to
is not,
cross-examine that.
I have brought certain 3 decisions. Well, only the application
Three
says.
decisions. You have brought the latest one also, 2025,
Valuswamy-
considering 2011, volume 11.
KK Valuswamy is 2024 Calcutta. KK Valu
Not
2011.
Calcutta, I'm talking about Supreme Court, which reiterates 2011, volume 11 Supreme Court cases. 2011, volume 11 considers 2009, volume 4.
Yes.
That is by Justice Kabir. 2009, volume 4.
Well, only. Well,
You have not brought that
Our Lordship,
Justice Partiwala's judgment of 2025.
our Lordship, my Lord, 2024 judgment, that only the allegation document could not be traced out. That application cannot be allowed to fill up the omissions in
Yes,
the
2009, volume 4. 2011, you have brought.
2009
This
and
has been
2000.
followed. This has been followed in 2025. 2011, volume 11. Yes. So this paragraph, how can you come out of this?
My Lord, the law is very clear, my Lord, on this aspect. You cannot make an application at the village stage at the
Filling
time
up
of
the
argument.
lacuna-
Argument has been started. But defense side, well, evidence has been, of both the parties have been closed. Learned trial judge fixed for argument of the suit. Argument starts. Now it came in with an applications. Now the defendant was about to complete the argument. At that juncture, came with the application recalling of the witnesses. And the applications says that the documents could not be traced out. plaintiff test of the document. Well, 2024 Calcutta, my lord, that is not the ground. Application can be allowed. And K. Belusham is, my lord,
2024 Calcutta, did it consider 2011 volume 11?
yes,
SCC,
2011 considered.
where? Show me that. Yes, paragraph 2016, which reiterates was considered.
K. Belusham is, my lord, considered.
Yes,
2009 also considered.
yes.
But the application, my lord, it was not, it was turned down by this, by your lordships. No application cannot be allowed. There is no foundational basis. Only the allegation, only the statement, document test out. Test out that there is the foundational basis. You cannot make an application at the village stage. Argument feast, argument starts. Paragraph 29, 2009 considered. Paragraph 30, K.K. Belusham judgment considered. In this case, learned trial court rejected the application under section 181. That has been affirmed by this honorable court. Two 2016 also considered. Recall could not be matter of right. Merely for asking, the application could not be entertained by the learned trial judge. Apart from this, the documents sought to be produced. There is no pleadings to that effect. There is nowhere in the plaint such and such incident. Beyond the pleadings, no evidence can be permitted to be produced or adduced. There is no aberration in the plaint with regard to the documents sought to be produced. Well, kindly see the paragraph 26 that the EIR 2024. If the party had an opportunity to produce the evidence earlier but did not do so, the object of the application for recall of witness was only to protect the proceedings. The court should reject the said applications.
Show me the evidence, what they have
Yes.
stated.
Well, it starts from page 66.
66.
Suit was filed on 5th January 2012. Evidence starts PW. Well, page 66 starts.
Yes.
So many documents are marked exhibit 1 to 12. Now cross examination, well, page 71.
71.
Yes. Defendant number 1, that is the petitioner before lordships. Defendant number 1 has constructed asbestos shed on the boundary wall by encroaching the demarcated portion as gifted to me by my mother. Other than this, defendant number 1 has not done any encroachment, no construction. And whatever construction has been done by the defendant number 1, that is the petitioner before lordships, made according to the sanction plan. But the answer of the PW1 is, apart from this asbestos shed, nothing has been done by the
Where
defendant.
is that admission?
Well, Lord, it is page 71,
71, yes.
third paragraph. And further admission, Ms. Wage has directed given a warrant to repair the AC shed. That document was tendered to the PW1, marked exhibit. I have also annexed that document, page 82. The remaining construction work has been done by the given number one on his demarcated
There's
property.
substance in this argument of Mr. Ghosh. Take it back. Judgment গুলো দিয়ে দিন।
May I please, your lordship?
Yes.
In this matter, my lord, I am appealing for the petitioner. My lord, I have challenged the order of rejection by the learned executing court. My lord, in respect to a report of the partition commission.
Yes.
Partition commissioner's report, my lord, I made an objection. Plaintiff made an objection before the executing court. My lord, that there are some infirmities and irregularities in the report and filed objection, and that was rejected.
Who is Ajay Kumar Mitra?
Ajay Kumar Mitra is the plaintiff. My lord, there are, my lord will find from the cause title, petition number 1, 2, and 3. My lord, 1, 2, 3, and the.
No, why the learned trial judge has said Ajay Kumar Mitra has no locus standi?
Yes, my lord, yes. My lord, two brothers and two sisters. And my lord, now, we are three, serial number 1, 2, and 3, my lord, different number. Plaintiff number.
That is the order dated 30th of July 2024.
My lord,
That is the order dated 30th of July 2024.
that is 30th of July, that is page 27. Twenty-five onwards. Alert plaintiff number 1 and different number 2 and 3. All are before your lordship, my lord.
By the order. Yes, next.
My lord, number 16. Order, my lord. Until interim order.
Please wait. Yes, call the next matter. 16 yes.
Item number 16, my lord, I am for the petitioner.
Yes.
My lord, the matter relating to, my lord, the petitioner before your lordship is the defendant tenant. My lord, my Mr. Mukherjee is.
Yes.
Lord, here is a case, my lord, where 7.1 and 7.2 application has been filed within the statutory period of limitation. This is a caveat. Appear করছে?
Yes, there's a caveat.
Yes, my lord, we have already served.
Yes.
Now, 7.1, 7.2 file within time. What pleading taken in 7.2, kindly come to page 27. There is a previous suit, my lord,
Yes.
treating me to be a defaulter.
Yes.
That suit ultimately, by the first appellate court, we got the protection under 17.1 and 17.2. Challenging that, our contention is that even we are not defaulter in that. There are, my lord, evidence on record showing that there is a payment of rent, so I am not a defaulter. Challenging that, second appeal preferred, second appeal admitted by the Honorable Division Bench under Order 41. So that issue with regard to treating me to get protection under 17.1 and 17.2 is not yet, my lord, adjudicated or attained finality. Because why I am saying this, because this suit is filed as if I will not get protection under 17.4, 7.4, now 7.4. Since I have got, my lord, once that protection under section 17 of the old act. But still then, my lord, I filed 7.2. What is my pleading under section, my lord, 7.2, page 27 of my lord's brief, kindly takes up paragraph 3. That it is denied that the defendant is a habitual defaulter in payment of monthly rent since long. It is a fact that the plaintiff filed a suit in the year 2010 for eviction against the defendant on the ground of default, being ejectment suit number such and such before the learned fourth bench, small causes court at Calcutta, and the said suit dismissed on contest. The defendant all along deposited the rent before the learned court in that suit, so he is not a defaulter. That the defendant filed an application under section 7.1 of the West Bengal Premises Tenancy Act 1997 in time before this learned court for permission to deposit the current rent month of August 2023, because this suit is of 2023, treating me from a defaulter of September 2013. That thereafter the plaintiff, being aggrieved and dissatisfied with the order dated such and such, filed a title appeal that is in connection with the previous suit. And the learned judge, 9th judge, Civil Court, passed an order.
Decree was passed.
That
2011.
Yes. Decree was passed in 2011. They preferred a title appeal, and the learned 9th judge, Civil Court, passed an order that the defendant is the first defaulter as per the provision of such and such. The judgment and decree passed by the learned.
December 2011. Now this suit has been filed alleging that you are a defaulter from September 2013.
That is the
Yes, that is, blood. I have annexed the plaintiff. If you lost
earlier suit for eviction was dismissed.
Initially dismissed. Appellate court modified, said no, I will get protection since I am a first defaulter.
So suit dismissed.
Suit dismissed. Ultimately suit dismissed.
Yes.
But finding of the learned,
They have preferred a second appeal.
they have preferred a second appeal.
Why?
Because, my lord, the finding that I will get protection under section 17.4, not 17.4, 7.1 and 7.2, that was incorrect.
Not here, in the earlier suit.
Earlier suit. Appellate
Earlier
court
suit
said-
is not 7.174. That is 17.1.
No, 7. Blood, I was wrong, blood. It's 2010 suits, that's why 7.
Oh.
2010 suit, blood, I was.
So it was, you said that 56
No, blood,
Act. All right. So 7.4.
7.4. So the present,
According to you,
even I was not to be held a defaulter in the earlier suit. So no question of getting protection under 7.1, 7.2. That's why I preferred a second appeal admitted under Order 41. But I will come to that, blood, that your lordship can say whether, blood, when the judgment is in your favor, whether the finding.
I'm not on that. Do you have a copy of that judgment? Of the appellate court?
Appellate court.
Appellate court.
The order,
Because the suit was dismissed. So there you have also complied with 7.1 and 7.2.
because the regular rent was paid before the
So 7.1, 7.2, if there is compliance, So suit is dismissed on the default, not that presupposes that you are getting a 7-4. Now, preferring an appeal, you are aggrieved that you say that I do not want 7-4 relief. That means
No.
you have to be.
I have not said that I will not get 7-4. Yes. Why? Because I am not a defaulter.
Yes. So that's a different thing altogether. That's a different thing altogether. 7-4, you will not get in that.
7-4 is not for the
7-4
subsequent proceeding.
Yes.
Yes, that's why
So 7-4
7-4 is the
relief under the Consistency Act.
এইটা বলেছিল যে প্যারাগ্রাফ 7টা দেখো
হুড়োহুড়ি করলে হবে না।
রাফেলে যখন চাচ্ছি সেটা হচ্ছে এইটা মডিফাই করি এই লাইনটা একটু
7-4, when you comply with 7-1-7-2, 7-4 is automatic.
Automatic.
Yes.
I will get automatic protection proviso.
Mr. Mukherjee, first part will apply in the first suit. You comply with 7-1-7-2, 7-4 relief. Proviso comes in the second suit.
Second suit. That's why.
So,
They are
but what is your appeal? I could not now comprehend. Till now, I could fail to understand what's the scope of your appeal there.
because as per me,
Because you have
the
got
appellate
relief
court-
under 7-4. According to you, you are not entitled to 7-4 relief.
yes, because I have paid rent, but I have shown before the appellate court also that I am not a defaulter. So still then 7-4 relief could not have been granted to me because I was not defaulter even in that suit. That's why not kindly see the order 41, the order.
Yes.
I have annexed page 35 once your lordship takes up. I am not, I am a defaulter. No eviction decree has been passed in that suit. But holding that, yes,
Eviction degree is passed, no relief under section 7-4. That's much is clear. Yes.
now in the present suit, they have treated that I am a defaulter, paragraph 5 at page 20. I am a defaulter since from the month of September 2020, 2013. Now, I filed 7-1 and 7-2. Kindly takes up 7-2. What I have stated, paragraph 6.
Yes.
That the plaintiff has deliberately filed his suit allegedly claiming that the defendant default since from the month of September 2013, which is denied by the defendant. The defendant states that he is not a defaulter in making payment of rent since September 2013. Furthermore, the defendant paid rent up to July 2023 at the rate of rupees 600 per month. That is the contractual rent as per the plain case also. According to the English calendar month before the learned rent controller, Calcutta, in the credit of plaintiff being such and such number.
So rent controller. And thereafter, there is no admitted default.
No admitted default.
So what has been held by the learned
Yes,
trial?
kindly takes up now the order impugned.
Yes.
The learned trial judge is of the view that the entire rent control challenge was being produced before the trial court. The trial court is of the view for August 2019, 1 month, and October 2019 to September 2022, the premises number was 150.
So those were treated to be invalid deposits.
Yes. And treating that said, since non-compliance of 7-1 will be there
is substance in the submission.
My lord, I am for the petitioner. Actually, on 29th January, I have filed one petition for under section 151 before the trial court.
For what?
Actually, my lord, order 9 under, I have repeatedly filed to ex parte vacating petition, and learned trial court rejected those petitions on grounds of, on flimsy grounds, none moves on etc. So that is why my petition was 151 petition. Actually, I claim that if I could not show any good cause, actually my presence, I have been present in suit till 2023, but learned court does not entertain me by anywhere in anywhere process in the proceedings. That is why I have filed. My lord, if you kindly look page 14, the 151 petition. In paragraph 6, my lord, I have explained the legal position.
Where is your application under section 151? Have you paid for setting aside this ex parte order?
Yes, my lord.
Where is that?
My lord, that is, I have not annexed. I have just my petition, 151 petition, I have annexed here in page number 14 of the of this petition, my lord. Sir, I have delineated on 20.
What happened to this petition?
This the 151 petition has been dismissed on non-moves in spite of my adjournment petition, my lord.
This you want ex parte to be vacated, and on that day also you wanted adjournment. Rightly rejected.
My lord,
rejected. There has to be an end of.
My lord, actually, on personal ground, I have been suffered on severe back pain. My learned junior filed an adjournment petition therein.
Where are the parties? How soon can you serve?
Yes, my lord.
How soon can you serve?
Well, I can serve them through post, my lord. I can serve them through post.
Post, courier, whatever you do, I am fixing it on Monday. Do that by this time.
My lord, on Monday, trial court fixed the.
That is why I am keeping it on Monday. For that purpose.
Okay, my lord.
If you can serve within Monday, yes. Otherwise.
Okay, my lord.
The petition is by the order.
But the learned tribunal says, I have reserved the matter for orders.
I am appearing, my lord, for the opposite party number 1. But
Yes.
I am only praying this. But I would like to do this matter physically before your lordship. But it is, my lord, I do not know which order has been challenged. An order has been reserved by the tribunal. That becomes a part of an order 227 petition.
All pleasure.
An order has been reserved. So that is why, my lord, I am saying, my lord, kindly till Monday, heaven, nothing will happen. Kindly keep it on Monday at the top. I will be there. But I'm praying only for this day.
Can you hear me for half a minute?
How can an order be challenged which is reserved? And he has mentioned a matter before the special bench. Special bench is not allowed mentioning because the matter has been reserved, and a 227 comes challenging that the order has been reserved. I fail to understand, subject to correction, how 227 can lie. But I would like, if your lordship is inclined to hear Mr. Shah, kindly keep it first matter on Monday. I will do it physically, my lord.
What will happen if I keep it?
My lord, I'll tell you, lordship, what will happen. This is the only question I want to answer. My lord, this involves insolvency of a company called Hindustan National Glass,
which till its insolvency controlled, my lord, 75% of the glass market of India, not of Calcutta or West Bengal. 75% of the glass market of the whole of India. The resolution plan, my lord, is valued at 22,500. 2,000.
What is the point in saying that we are on the 227 maintainability?
Yes.
2,200 crores. Now, my lord, we have, the plan has been approved by the COC, we say, my lord, which is in grossly illegal fashion. My lord, we, my lord, challenge the plan. The Supreme Court, my lord, fixed the period within which, my lord, the objection to the plan had to be heard out. So, my lord, everywhere they go, whenever I ask for adjournment, Supreme Court's orders there, you can't adjourn. Today, my lord, my friend, my lord, asked for adjournment. Be that as
No,
it
no, I am not asking for adjournment on that ground. Mr. Shah, please do not put words in our mouth. I am saying that, my lord, only Monday I will come and do it.
May I, my lord, may I press, my lord, there is extreme urgency.
Yes.
Very
So,
well.
fixed a time frame.
Now, then here the question of maintainability. Kindly look at the prayers, how a 227 is maintainable.
How to make his submission. Yes.
Now, my lord, Supreme Court fixed a time frame, 6 weeks, please dispose it off. Calcutta bench started hearing the matter. For some reason, my lord, they recused themselves. It went to the president. President constituted a bench in Calcutta, a special bench, comprising of the 2 members who sit at Cuttack. They came personally, and the direction on them was, which is in there in the notification, that they will sit and hear this matter till it is concluded. Before that, they will not go back to Cuttack. So they came to Calcutta, they held court, my lord, for 7 days continuously, and my lord, they reserved orders, my lord, on, my lord, the 10th of July. Now, my lord, once they reserved the order on 10th of July, my lord, a meeting was held by the COC on the 14th of July. In that meeting, for the first time, we find that, my lord, the successful resolution applicant who has put in this plan, my lord, of 22 crores, has said that if the insurance company does not pay the money in respect of the unit that has burned down, which, my lord, is estimated to be about 500 crores, then we are not interested in proceeding, then our plan becomes unviable. The views, my lord, and I'll show your lordship the provisions, my lord, of the code, which say that the first thing that the court has to see while approving the plan is whether the plan is feasible and viable. Feasible and viable, that these are the 2 words used. My lord, in the letter of the SRA, the successful resolution applicant, to, my lord, the COC and the RP, he says that if the insurance amount does not come, the plan becomes unfeasible and unviable. Now, my lord, this letter, if it had been there, and if it had been shown, my lord, because this is a letter of 30th June. 30th June is when, my lord, the bench started hearing the matter, concluded the hearing, reserved it for orders on 10th July. If this letter of 30th June had been shown either by Mr. Sen's client, my lord, who, my lord, the COC, lenders, by Mr. Jishnu Chaudhary's client, my lord, who is the RP, my lord, by, my lord, the successful resolution applicant, whom, my lord, I think Mr. Thakkar represents, none of these 3 people, my lord,
present, but I have not been impleaded. Just to let your lordship know.
Yes.
Reliefs are sought against
because at this juncture,
everything is sought against me, but I am not impleaded.
At this juncture, my lord, I am not seeking anything against anybody. The learned judge has said I have reserved for orders, therefore I am denuded of the jurisdiction to entertain any further application.
What is the application you wanted to?
My lord, I wanted to move the application to bring this one letter on record and for the court to take cognizance of that letter. Because, my lord, my contention is that
that letter was argued on 10th of July for the NCLT by Mr. Thakkar's client. It was argued. We have objected to that. The tribunal has taken note of that. So it cannot be the case that this letter of 30th June was not argued, was not brought on record.
My lord, kindly have page 148 for a moment, my lord. Kindly have page 148 for a moment.
Yes.
Kindly have page 148 for a moment, my lord.
Yes.
My lord, at page 148, my lord, your lordship will see, my lord, this is the notification kindly see the date of the notification 30th June 2025. Then, my lord, after paragraph 2, kindly see special bench at NCLT Kolkata. This is the notification issued by the president constituting the special bench at Kolkata. Honorable members so and so and so and so. My lord, these are, my lord, the members at, my lord, Guwahati. Then, my lord, kindly see at Kotak, my lord, I'm sorry. The constitution of bench is as per section 419. Then the honorable members shall sit physically at NCLT Kolkata from 3rd July 2025 regularly and complete the hearing. This was the urgency of the matter. So, my lord, the bench convened, my lord, shortly thereafter, 30th June, my lord, they started hearing, my lord, 1 or 2 days thereafter. Now, my lord, kindly have, my lord, the letter, my lord, in question at, my lord, page 103. Kindly, my lord, have that letter for a moment. This letter, my lord, before I place the letter, I want to tell your lordship, we got this letter, my lord, on, my lord, 12th July. That is our pleading. At 103, my lord, your lordship will see, this is a letter on the letterhead of this, of, my lord, the successful resolution applicant who goes by the name of Independent Sugar Corporation. That's page 103.
Yes.
Now, my lord, kindly see the date of this letter. The date of this letter is 30th June 2025. So, my lord, in the 10 days of hearing, and the bench sat day to day, they did not, my lord, bother to disclose this letter. Now, my lord, before I take your lordship to this letter, my lord, HNG had, my lord, about 13 units. My lord, amongst these 13...
This letter was addressed to the COC and the...
Yes, yes, my lord, so grateful.
Yes.
So, this is a letter written by, my lord, Mr. Thakkar to Mr. Shakoshen and Mr. Jishnu Chaudhary. None of the three of them, my lord, produced this letter in court. Now, my lord, out of the, my lord, 13 units, my lord, that HNG had, my lord, the jewel in the crown, my lord, was a unit, my lord, at, my lord, Sinar. This, my lord, unit, my lord, completely burnt down while the matter was pending, my lord, consideration. Completely burnt to ashes. Now, my lord, your lordships are, my lord, conscious of the fact that, my lord, proceedings before the NCLT are not for recovery. They are, my lord, they replace, my lord, the, my lord, BIFR Act and, my lord, the liquidation proceedings. So, they are for resolution. So, my lord, the basic purpose behind the code is that, my lord, the industry will be restarted. Therefore, my lord, there was also a lot of litigation saying, how do you restart the industry? At that juncture, my lord, the RP, my lord, Mr. Chaudhary's client, my lord, invited, my lord, experts who came and said 480 crores will be required for reviving. Now, my lord, today, in this perspective, my lord, kindly see this 30th June letter written by Independent Sugar, both to the RP and to this and to the, my lord, COC. Kindly see, my lord, from the second paragraph of the letter. Or, my lord, first paragraph, we are writing in our capacity as SRA of Hindustan National Glass. This letter specifically pertains to the Sinar plant of Hindustan National Glass, which has remained shut since December 23 following a massive fire. Then, my lord, next paragraph. Massive fire. The restart, my lord, may I read, my lord? The restart and operational viability of this plan, this 2200 rupee plan, crore plan.
Of this plant.
The restart and operational viability of this plant is fundamental to the financial feasibility, valuation assumption, and overall business continuity that underpin our resolution plan. It is therefore both our right and our duty to seek clarification and action from the COC and the resolution professional regarding the status of the insurance coverage of the preservation of the plant and its assets in line with the obligation of the RP under section 25 of the Insolvency Code to protect and preserve the assets. Now, my lord, kindly see, my lord, the next paragraph. From the information available to us, we find, my lord, COC has operated for reinstatement option under the applicable insurance policy. So, your lordship finds, my lord, that the COC, Mr. Shakoshen's client, my lord,
has already applied to the insurance, my lord, to get this insurance claim. Now, my lord, insurance claim, whether they will get it or they will not get it. If they do not get it, then, my lord, one set of circumstances follow. If they get it, my lord, well and good. If they do not get it, my lord, now kindly see what is their own admission. Kindly come straight away, my lord, to page 104, my lord, second paragraph.
Yes.
And my lord, I'll read this slowly. The consequence of failing to meet the insurer imposed deadlines are grave, including the forfeiture of insurance reimbursement, which will directly impair the feasibility of our resolution plan and cause severe financial implications for INSCO, which are unacceptable to us. So, my lord, kindly see the use of, my lord, two words, directly impair feasibility of our resolution plan. My lord, after that, immediately thereafter, my lord, kindly, my lord, now take. My lord, now, my lord, kindly take, my lord, section 30, subsection 4. একটু দেবেন না জজ সাহেবকে একটুখানি বইটা দিন দেখাচ্ছি my lord, section 30 subsection 4, my lord, section 30 is after, my lord, the plan is approved by the COC, Committee of Creditors. It comes, my lord, to the tribunal, my lord, for, my lord, the tribunal stamp of approval to the plan. There, my lord, your lordship will see submission of resolution plan. Resolution plan will be submitted, my lord, by the resolution professional, so and so, so and so. Kindly, my lord, come to subsection 4. So, section 30 is the provision under which, my lord, the court grants its seal of approval, my lord, to the resolution plan. Kindly see 4. The Committee of Creditors, subsection 4 of section 30. The Committee of Creditors may approve a resolution plan by a vote of not less than 66% of voting share of the financial creditors after considering the feasibility and viability of the plan. So, my lord, the feasibility and viability of the plan is fundamental to the entire process. And here, my lord, your lordship, my lord, has a letter from, my lord, this person who has put in a bid, my lord, for 2,200 crores, saying that if the insurance policy is not available, then the feasibility and viability of my plan, my lord, gets, my lord, impaired. So, my lord, the plan, he himself says, my lord, may not be cannot be implemented. It cannot be implemented, it becomes unviable. My lord, now, my lord, kindly, my lord, permit me to just read one more paragraph, my lord, of the letter that I was showing to your lordship. Page 105, I was showing 104. Next page, my lord, at the top.
Yes.
The continued inaction and delay in finalizing and incurring necessary capex for the reinstatement of the Sinnar plant as required under the NIL insurance policy will not only contravene the Supreme Court directions, but will also severely undermine the commercial viability of the resolution plan, exposing the process to avoidable legal and financial risks. My lord, the letter has further details, but I need not, my lord, trouble your lordship further. So, my lord, from the two portions that I read out at paragraph page 104 and 105, your lordship sees, my lord, all this while I was trying myself hoarse that, my lord, the plan is unviable, not feasible, unviable. Now, my lord, they are themselves saying that, my lord, if the insurance company does not pay, it becomes unviable. The insurance company, my lord, as on the date of, my lord, the matter being taken up, has not approved. Now, my lord, one of the fundamental principles, my lord, and I'm, my lord, armed today with, perhaps I don't need to, my lord, trouble your lordship with that, with at least, my lord, 5 decisions of the Supreme Court, my lord, which say that a conditional plan cannot be accepted. There's a bar to the acceptance of a conditional plan, my lord, Supreme Court has laid down in IBIC Singapore. If a plan says, if the insurance company allows this money, very well, my plan stands. If it doesn't, it fails, it becomes unviable. So, my lord, if a plan is conditional, then that plan, my lord, cannot be considered by the COC. That's the law. And my lord, whether that is the law, not the law, whether, my lord, the SRA meant what it said in this letter, did not mean what it said in this letter, my lord, comes later. My lord, all that I did, sorry. All that I did, my lord, is that, my lord, I made an application. I'll show you, Lordship, the praise in my application.
Where is that application?
My lord, that application is at page 49. My lord, kindly see, my lord, page 53 straight away, which are the
51 in the matter of the dekhi raha, second in the matter.
Acha, very well. My lord, kindly come to page 51.
51.
Yes. My lord, kindly see. And in the matter of an application is being filed seeking appropriate orders of rejection of the revised conditional resolution plan dated 8 June on the grounds set forth below. This application is necessitated due to the subsequent discovery of a letter dated 30th June 2025 addressed to the COC and the RP, which was placed and discussed during the 42nd COC meeting scheduled for 12th July 2025, but actually held on 14 July 2025. However, the said letter being material and relevant was deliberately suppressed by the RP and the COC during the hearing of the plan approval application, which was reserved for orders on 11 July 2025. Now, my lord, the matter is reserved for orders.
So, when you came to know of this,
My lord,
that letter on 14th of
my lord,
July.
my pleading is on 16th July I came to know. That is at paragraph 6.
Page 79.
Kindly take, my lord, page 79.
78.
78.
79. 79.
Kindly take my pleading, my lord.
5 and 6. 5 and 6.
Paragraph.
My lord, kindly take it from paragraph 5 at page 78 bottom. The applicant has filed the present application to bring on record the subsequent development in the CIRP of the corporate debtor, which are material for adjudication of the plan approval application bearing number so and so. This application arises from the discovery of a letter dated 30th June addressed to the COC and the RP, which was discussed only in the 42nd COC meeting held on 14 July and after the matter was reserved for orders on 11 July 2025. Despite its material relevance to the nature, feasibility and viability of the resolution plan, this letter was deliberately suppressed by the RP and the COC during the plan approval proceedings and never brought to the attention of the Honorable Court. The applicant has recently learned from INSCO, that INSCO, my lord, that's the SRA, issued a letter dated so and so seeking immediate clarification from the respondent regarding the status of the insurance for rebuilding of the Sinnar plant. Applicant obtained a copy of this letter.
So you wanted to file this application.
My lord, the reason, my lord, why I'm personally, my lord, the reason why, my lord, I'm personally present, my lord, before your lordship is that, my lord, after, my lord, over here, my lord, the filing is online. After the filing was done upon notice to my friends, my lord, we mentioned the matter. I mentioned the matter.
So filing has been made.
Yes, yes. Filing has been done. My lord, the learned judge, my lord, judges feel that, my lord, once a matter is reserved for orders, then no further application is.
Where is that finding?
Para 12.
Milord, I'm going to pay for.
Where is that?
Let him show that. There's nothing.
But there is no finding anywhere.
Your lordships will also be here as your lordships.
Well, let me show you my pleadings. Let me show your lordship my pleadings.
Yes.
My lord, I am a little taken aback because, my lord, many of, I don't know, my lord, if
No,
my
I was there.
friends.
When he mentioned the matter before
My lord, kindly have.
not a matter before the Odisha bench. He's written a letter to the president asking for a
Bhagavan.
Now
He'll get his chance. He'll get his chance. He'll get his chance. He'll get his chance.
Getting anxious at the.
Mr. Sharp,
Yes.
told me that you have filed this.
My lord,
Application has been filed.
my lord, application has been filed.
Yes.
After filing, my lord, it has to be mentioned
Yes.
Particularly because this is a special bench.
Yes.
So we mentioned the matter. Upon the
Mention the matter before that particular bench. Chaudhary, please. The special bench was constituted. They sat for a particular time in Kolkata.
Yes. Now, my lord,
They are not available in.
my lord, I'll tell you, lordship.
When you file that application, it is not in Kolkata. The members were not in Kolkata.
No.
So where did you mention?
In Cuttack. We mentioned in
that
Cuttack.
particular bench is.
My lord, that particular bench is the regular Cuttack bench.
Yes.
So they were told to abdicate my lord, their jurisdiction in Cuttack, come to Calcutta for this matter, do this matter. They were doing my lord Cuttack virtually, my lord, when they were in Calcutta. Half a day they were doing Cuttack virtually when they were in Calcutta. So my lord, this bench is the regular Cuttack bench. So my lord, I filed it with the registry. And my lord, thereafter I mentioned, my lord, because the composition is available. It's not that I had to again write to the president, my lord, to make that bench convene. The composition is available. And that's not the ground on which they are not hearing it. They say that number one, Supreme Court order, matter has to be disposed of within a given time frame. That time frame, my lord, is long gone, but be that as it may, matter has to be given. Secondly, my lord, the ground told to me, my lord, is that, my lord, 140 applications were already there. We disposed of so many applications. Now you come with another application. Don't want to hear you.
Where are those?
My lord, may I tell you, lordship? So, my lord, if I filed an application, it has to come up for hearing.
Yes.
It has to come up for hearing, my lord. I understand my learned friend, my lord, stating with all the emphasis, my lord, which he commands, that, my lord, there is no other. Now, my lord, that is my specific case.
Where have you stated?
My lord,
Page 13, paragraph 12. Sir.
Yes.
13.
Kindly, my lord, permit me to place that case, that relevant portion.
Main application, page 13.
My lord, kindly have page 12.
Page 13.
Page 13. I'm sorry, my lord, page 13. Thank you. Thank you. Very good. In such circumstances, the petitioner caused, I'm reading, my lord, paragraph 12. In such circumstances, the petitioner caused IVNP, this is the one that I want heard, IVN 25 to be mentioned before the same honorable members of the special bench while sitting at NCLT Cuttack bench on 22nd July 2025 upon prior notice to the respondents. A copy of the said notice of mentioning dated 22nd July is annexed, marked annexure H. This is, my lord, at page 143, my lord, of, my lord, the petition before your lordship. Then 13. However, the honorable members of the learned special bench declined to entertain the plea of the petitioner to take up so and so on the ground that the matter had already been reserved for orders pursuant to the order dated 10th July and 11th July 2025. While making such observations, my lord, this is, my lord, not necessary. This is, my lord, the urgency. So, my lord, I have filed an application. Now, my lord, the learned court, my lord, may, my lord, be, my lord, of the view that once a matter is, my lord, reserved for orders, no further application is entertainable. May hold the view. My lord, I say that's an incorrect view, but, my lord, kindly, my lord, don't take that into account for the time being. But he has to entertain my application. Say your application is not maintainable because the order has already been passed and reserved. In the main matter, I will not entertain. Can he, my lord, in the utmost of respect, if I ask the question to myself, say, my lord, I will not bring it on board and I will not hear it. That's, my lord, my pleading. So, my lord, either when I file an application, either the registry, my lord, in terms of the rule, has to put it up, my lord, for hearing within 24 hours. If it is filed the next day, and after 12 o'clock, the day after. That is, my lord, the NCLT rule. So, my lord, because this is a special bench, my lord, I mentioned the matter. My lord, I can, my lord, I am not required to address your lordship on the merits. But, my lord, the only thing is if I file and...
Mr. Shah, why can't you bring to the notice of the Honorable President?
Yes, yes, that is the thing.
My lord, now, my lord,
that is the thing.
My lord, I have done that. I have done that. Now, my lord, I'll tell your lordship. Kindly have, my lord.
Where have you stated that you have...
My lord, I have annexed the letter. I have annexed the letter at, my lord, page 145. 145.
Paragraph 14.
I have given, my lord, I have treated it also, but let me show you the letter directly. The document is also there. my lord, I wrote to the president saying the urgency. If he approves the plan, then my lord, the whole thing, my lord, becomes otious.
No, it does not.
Not at all, Your Lordships. It doesn't. He has
It
the right
does
of
not.
appeal. He has the right of appeal.
Okay.
Page
Yes, subject to correction,
Yes.
paragraph 14, you have said that you have given and submitted a representation, but you have not mentioned for constitution of that bench.
My lord,
Yes.
I have.
There are,
I'll show you the letter itself. The letter
you have
itself is
mentioned,
annexed.
you have mentioned before the.
Yes, my lord. My lord, kindly take the letter at page 145.
145 is the representation.
That's the letter.
Representation. Why
My lord,
can't you
these
mention
petitions
it
are by way
physically?
of representation.
Why can't you mention it physically?
Yes, before the president.
Physically, Honorable President.
My lord, I'll tell you. My lord, I'll tell you.
Because Mr. Shah, there are two things. One is for a particular period,
Yes, my lord.
the members were directed, they were appointed to hold seat here for this hearing.
Yes, my lord.
Now they are in Cuttack.
Yes.
Now, whether or not a special bench will be constituted for this again, or virtually or physically, that's the president can decide.
Yes.
My lord,
So why
things have been done.
147 is there.
All these things have been done. My lord, this is a, my lord.
So this is the prayer.
No,
This is
no.
the prayer which you have made. Why can't you mention? Please
No, no,
mention,
my lord.
Mr. Shah, please mention.
Your Lordships, if it is.
Now, my lord, your lord,
Mention today physically.
Yes.
my lord, may I say this? My lord, the procedure, my lord, there is first of all, my lord, there is no procedure. We do this, it is entertained.
What, no procedure for?
My lord, no. Of course, you can mention. There is no. I'm not trying to say there is no mentioning. Of course, you can mention. My lord, this, my lord, request, my lord, that, my lord, the matter should be taken up because, my lord, he does not exercise, my lord, appellate jurisdiction over the bench.
Not a question of appellate.
The only thing is the bench that has been constituted
by the president
has not been, my lord, discharged.
Yes.
Now, my lord,
Now,
this is
question is where to be these sittings to be held on
no,
that particular.
may I say this? My lord, if he wants us even to go to the hearing, we will do that.
That is right.
So, my lord, the point is he put it up. He says,
Mr. Shah, why can't you mention it today physically? I'm keeping it on Monday.
Please,
Go.
if he wants for a hearing, he should take us with him.
Yes, my lord. Mr. Shah should take us. We won't be taken otherwise.
Parties also. Other only option is.
my lord, may I just say this? My lord, may I say this? My lord, may I say this?
Example of
My lord, may I say this? May I say this? My lord, at my lord, page my lord 136, my lord, your lordship has seen that a bench has been constituted.
Yes.
At page 148, there is a notification constituting the bench. Now, my lord, if I want a matter to be heard, for example, my lord, if I want, my lord, the civil division to be heard, I don't go, my lord, to the Chief Justice saying that direct, my lord. My lord, so I have gone there. I have mentioned.
Yes.
He is declined to take it up.
After that, Mr. Shah, why did you make a representation before the office?
Yes.
Why make a representation?
My lord, I'll answer that. My lord, I'll answer that. My lord, I'll answer that. My lord, I'm prepared for this question, my lord, because I knew your lordship would ask me this question. My lord, twofold reply to this question.
Shah, instead of going to that, can you not mention
My
before?
lord, may I do this? My lord, kindly keep this matter on Monday.
No.
Kindly keep this.
5 minutes from your lordship.
But I will also take only 5 minutes, my lord. But kindly.
Application should not be. I'm not finished. I'm just responding to, my lord, what the court has said. So, my lord, he should wait for his turn. I'm sure, my lord, your lordship will hear him. Why is it? Why? Of course, my lord, he will get his 5 minutes or 50 minutes according to, my lord, what the court desires. My lord, there are 2/4 submission which I wish to make, my lord. I won't occupy your lordship's time more than this. My lord, it is our stated position that, my lord, this view of the tribunal that once I have reserved the matter for orders is contrary to, my lord, the law, as, my lord, laid down by the Supreme Court. That's number one. Number two, my lord, is that I have filed an application. I have mentioned the application. It is my statement on oath that he is not ready to even lift the application. Therefore, my lord, I have no other opportunity to go anywhere else. Now, my lord, as a matter of form, because my lord, this is a special bench constituted by the president, I am duty bound to bring it to his attention. Which I have done, my lord, by way of a letter. That's why I have not filed a petition as such, per se. The petition, my lord, I have included, my lord, a prayer that please do this, do that, because, my lord, otherwise writing of a letter, my lord, does not make any sense. So, my lord, the question today is that, my lord, today, my lord, the president has also on that. Now, my lord, there is, again, my lord, very, my lord, grave doubt as to whether the president can, my lord, direct them that you entertain this application or do not enter, because he doesn't exercise appellate jurisdiction.
Can attempt today. I'm keeping it on Monday.
Very well.
Sir, I want
The difficulty, Mr.
Sir, I want to be heard for, sir, I want to be heard for 5 minutes before your lordship makes any observation. Because this
So
is,
you have
no, even an adjournment, even an adjournment.
What adjournment?
Application in the Milord, may I just take 5 minutes? Milord, this is a matter which was before the
Absolutely.
Kolkata bench.
Absolutely.
First, Milord, the two learned judges were hearing it. The president, in exercise of his powers under the Companies Act, took the matter away from two learned judges and kept it before the other available bench. One of the members of that bench, Milord, recused from the matter. And then, Milord, in exercise of powers under section 419 of the Companies Act, by Milord, the president of the NCLT in New Delhi, Milord, a bench was constituted. Please see that notification. Your lordship has no power to entertain this matter, and on facts, your lordship may not be pleased to entertain also. I'll show the complete abuse of
Then
process.
Mr. Chaudhary come at because I have a bench at
One. I'll come at 2
Yeah.
o'clock.
Yes, my lord, I will also make my submission, my lord. Only why I say this, my lord, it will set an extremely bad precedent.
In a matter. Proceeding extreme. He doesn't
Your lordships, the only thing I have to
My
add
lord,
to this, your lordships, is that the same petitioner has filed
just
a
one
fresh.
second.
Yes, sir.
But may,
I
may
just
I,
recommended a few days back. Very well. I want to. FIR pending.
Yes, yes.
my lord, I just want to say one thing. Kindly have a look at the nature of the order which has been prayed for. As Mr. Chaudhary submitted, my lord, even if your lordship, my lord, adjourns the matter, that means it amounts to entertaining the 227. Kindly see, my lord, the effect which it will have. You'll suppose, my lord, a trial court has made a matter CAV. Good or bad, it has been made CAV. Can that CAV be questioned? Today, my lord, he is coming up with a letter which has been argued threadbare. I say with this responsibility, it has been argued by Mr. Thakkar's client first.
I didn't have the
It
letter.
was, well, one second, it was opposed by Mr. Shah that once a plan has been approved by COC, it
The letter was there.
they cannot give a new condition to the plan.
Not addressed to him.
One second. The plan approval application is being heard on the basis of
Mr.
the
Sheikh,
plan which has been approved.
please allow him to make his submission.
Yes. Well, kindly see what is the effect. Today, if an order of CAV is opened, allowed to be challenged, what will happen before the lower courts? And there's wrong submission is being made that this letter, this new proposal of independent sugar was not considered. This was argued. A reply was given by COC. We specifically took the stand that after the plan has been approved, there can be no new condition. And the plan approval application has been heard.
This letter, the substance of this letter was argued.
Yes, it was argued. It was argued. I'll tell you, Lordship, who has argued? It was first placed by the learned senior counsel on behalf of independent sugar. It was replied by COC through the Solicitor General. And thereafter, Mr. Shah also made his submissions. It was argued threadbare.
Mr. Shed, I have a bench at 1, so please come at
2 p.m. Come at 2 p.m.
Yes,
Very
Mr.
well.
Please join at 2 p.m.
Yes,
Your,
I shall.
your
I
lordships,
shall.
I have a slight difficulty. Your lordship, only 2 submissions to make.
Yes,
One is this petitioner, your lordships,
No,
has
no.
also this petitioner has also filed an appeal before the Honorable Supreme Court. So the only thing I'm trying to espouse here is that your lordships, this is this is fishing in troubled waters.
Absolutely.
And the challenge here, lordships, is the more the time goes, the more plants are at risk. Now only one plant is gone down.
Wait, let the court say.
Yes. Yes, Mr. Bhagavan.
I apologize, your lordships. There's a lag. Your lordships, the more delay happens, the more the plants go down. Today, the grievance is with respect to one plant. There are 6 more plants, your lordships. And the difficulty is it is under these circumstances that the Supreme Court says in 6 weeks, under any circumstances, you have to approve this plan, your lordships. On the merits, I'm not going, your lordships. I'm not on the merits.
Let us not go into the merits, my lord.
Merits, even I have something to say on this issue in a very different light from Mr. Sen, but I'm not going into the merits.
No, I am not going into the merits. I am saying 227 cannot be invoked like this.
Mr. Sen, we are coming back at 2 p.m.
Very well. I shall.
Yes.
Purpose is to frustrate the order of the
Yes,
Supreme Court.
Heavy cost. Very heavy costs of suppression.
Yes, my lord, this cannot be, my lord. This should not be a precedent like this, my lord. Every order of the trial court will be reopened after it has been made CAV.
This is not my book. This is Milord, I think. Only Milord saving grace is Mr. Bhattacharya is appearing for them.
Only he can save them.
I was just Milord putting a question. Milord, if one day Mr. Bhattacharya falls sick, does not come to court, something happens.
Court should
What
not
will,
sit.
what will the rest of the bar do?
The court should not sit.
Exactly.
Yes, Mr. Bhattacharya, please give an answer. Answer.
He is talking about someone else.
No, we are about the Prabhu.
Yeah. আমি করবো তুই well, so item number 7, your lordship is pleased to take it at 12. Probably my lord today is hard pressed. Well, if your lordship fix it at Tuesday. Tuesday same hearing, so again.
Who is for your, who is the other side?
Opposite number. Yes.
Tuesday. Please.
Tuesday.
Claim has been presented at the time of hearing. There was an injunction. I run up a small injury. Every day the police is coming in along with the local because it's an influential person. But
What do you want?
the lead to file it
Without certificate.
File it, it will appear.
Injunction.
Because on Monday itself.
Why?
Because every day, it's an eatery. It's on the roadside. It's a roadside eatery. The person is very influential. It's not just the police.
File it, it will appear on Tuesday. One day nothing will happen.
There is no certified copy. There is no
You
certified.
have to file without the certified copy. You have the server copy.
Not even a server copy.
Then?
Because the influence is so much. I can't say it in open court because the streaming is on. Even the certified copy is not being granted to me.
So Chatterjee, how can I
An order, sir?
I will find out a way of getting that order before your lordship.
Please get it, then file it. Otherwise,
I cannot stand even for it.
otherwise, how can I take up that?
No, I will get, my order here is basically to hear out the application, and in the meantime, an interim order, because I was enjoying that with the, in the trial court.
No, but
Now, my application, is not being heard.
what is the application?
Injunction. Suit, is for declaration that I cannot be, dispossessed without due process of law. I was enjoying an injunction. Order 711 has been allowed me on some flimsy ground, so I have preferred an appeal. In that appellate court, I filed an application for injunction. My injunction application was listed for hearing. When it was listed for hearing, the other side paid for time. And then, the next day, the time is going on and they are not hearing my application at all. So, and every day, because the suit has gone, I had a police in action here. But police in action says that since the suit has gone, I cannot do anything. So I am cut from both ways.
If the suit is not there, how a civil revision application is maintainable?
Appeal is continuation of the case.
But without any order, Mr. Chatterjee, it's difficult. Need to file without the certified copy.
Item number 3, my lord. Item number 3.
Date as on Monday, so it will appear.
Monday it cannot appear, Mr. Chatterjee.
But item
Tuesday. One day, Tuesday, Wednesday, I do not know. 2 days, I think they take it.
Date on Tuesday, let it appear on Tuesday, and thereafter, whatever, whichever.
Lordship, I'm mentioning, my lordship, item number 40, your lordship. It was taken up on 23rd. Lordship, please to stay the arbitration proceedings. So, lordship, I'm not getting the server copy. Tomorrow is the date, lordship. Only communication, I'm not able to do it, lordship.
Well, item number 3, my lord, correction, my lord. Item number 3.
Oh, item number 3.
Yeah. Well, only it's a typographical mistake thing, my lord.
What typographical mistake?
Name.
Yes.
But in the order sheet, my lord, name is right. Name is right on the order sheet.
In the order sheet, name is correct. But in the petition, you have given an odd name. That is why it has
been... kindly be granted, my lord.
Asud.
Item number 349.
Not your matter.
I'm sorry.
There's a personal appearance.
On behalf of
You are
the,
appearing.
Three forty-nine,
My lord.
I am appearing on behalf of the petitioner.
Yes.
my lord, here is my compliance report. Money has
We have
also.
just received the copy of the affidavit of compliance. We want to go, my lord, we want to go through it. My lord, kindly keep the matter pending, my lord.
My lord, your lordship is actually
Gone through it.
supposed to
We just
actually
went-
compliance report should be given to the court first. There is no direction for actually giving affidavit to him, the petitioner. Here is my compliance report. Money has
Give it
disbursed.
to him. Give it to her.
My lord, already.
My- Just now,
My-
just now handed over.
Affidavit of compliance filed in court today is personal appearance is dispensed with.
My lord, in the last document.
Personal appearance লিখে রেখেছেন কেন এখানে? Personal appearance লিখে personal লেখা নেই তো বললেন।
My lord, that has already been there, my lord. Personal appearance. Already there by your lordship's last order.
Dispensed with.
Dispensed.
Yes. Yes, call the continuing. Yes.
Yes, Milord, now I believe it is my turn for five.
Milord, I have not finished. Let me
Not know. Let the matter be
finish.
called on. I also do not know
Call
what
on
matter
back.
will be called on. ডাকুন এটা continuing টা ডাকুন।
Your Lordships.
Yes. ডাকুন।
Item number 18.
No, my lord, if your lordship, my lord, will once, my lord, permit me to, my lord, just,
এই বইটা কোথায় গেল?
my lord, hand up to your lordship, my lord, before you take the code, before you take the code or the petition, kindly, my lord, take the rules once. একটু দেবেন।
Yes.
My lord, I think, my lord, this matter does not deserve your lordship's consideration for more than, my lord, a minute. My lord, kindly take rule 13.
Rule 13.
1-3.
আরে জয়দা কেন চেয়েছে? হ্যাঁ, ঠিক আছে, ঠিক আছে।
দরকার নেই। Yes.
Listing of cases. An urgent matter filed before 12 noon shall be listed before the tribunal on the following day. If it is complete in all respects, as provided in these rules, and in exceptional cases, it may be received after 12 noon but before 3 p.m. for listing on the following day with the specific permission of the bench. Now, my lord, I have listed it. It is defect-free. It has been given a number, IBN 25. Therefore, my lord, in accordance with the rules, it has to be listed. And if it is listed, my lord, then, my lord, it is up to the learned tribunal whether to, my lord, accept my prayer or reject my prayer. But, my lord, the only question, my lord, which I seek to canvass before your lordship today is, my lord, if I have filed an application, if that has been allotted a registration number, then that application cannot evaporate and go away. In some way, it must be dealt with by some form of judicial or administrative order. My lord, the learned, my lord, tribunal cannot, with the utmost of respect, my lord, say, I will not hear you. So, my lord, shorn of, my lord, all the background of the matter and all the, my lord, heat, my lord, and energy that it has generated, this is the only question which we are seeking to canvass. Now, my lord, whether the application is meritless or worthless or, my lord, full of merit, whether that, my lord, letter should be brought on, not brought on record. Here, of course, my lord, I just want to, my lord, make a personal clarification that, my lord, if my learned friends, my lord, are contending that the letter is brought on record, then, my lord, that would be the end of the matter because it is not brought on record. If they can show one document that that letter was on record and it was considered, then that's the end of the matter. I have not moved my application. But, my lord, the only question, my lord, we are really speaking, my lord, not concerned with any other aspect, my lord, but, my lord, whether, my lord, an application once filed, my lord, it becomes duty incumbent on the bench to hear that application. That is all. And, my lord, insofar as, my lord, the objection on the basis of which, my lord, it is my pleaded
case on oath that the tribunal is refusing to hear me. With regard to that, my lord, I just want to rely upon, my lord, two small decisions. Just to, my lord, meet, my lord, the point that, my lord, even if, my lord, the matter is reserved for orders, in appropriate cases, my lord, any sort of objection can always be entertained.
Yes.
My lord, first of all, my lord, let me start by saying, my lord, once a matter is reserved for orders, my lord, there is no provision really which says, my lord, that you cannot touch it again. My lord, there are several, my lord, authorities, my lord, let us say for in the case of amendment, subsequent with anything, my lord, even after, my lord, is reserved for orders, my lord, lordships have permitted amendment, my lord, of the pleadings. Amendment of pleadings has been permitted after reserving a matter for orders. So, my lord, I am, my lord, a little perplexed as to, my lord, what is, my lord, the holy cow about the matter being reserved for orders. My lord, today if there is a subsequent event, today if there is a subsequent event, today if the court, my lord, notices a mistake, today if the court, my lord, after reserving the orders wants clarification, 10 times, my lord, your lordship put it back in the list.
Strain your voice so much now. We have put a
Microphone. We will have the volume increased if he wants.
Now, my lord, I'll tell you, lordship, my lord, the one thing, my lord, which we took very seriously, my lord, when I was addressing your lordship in the first session, is, my lord, your lordship, my lord, said that if you've gone to the learned precedent, then go and mention there. My lord, my lord, when your lordship rose, my lord, the tribunal rises at 2:30. We mentioned before rising. My lord, not entertained. Mr. Shonak mentioned, not mentioned, and, my lord, I need not repeat, my lord, what was said. I need not repeat it. But, my lord, suffice to say, mentioned, not entertained. So, my lord, the question is, my lord, if I have the question, my lord, the only question which begs your lordship's kind consideration is, if I have a grievance, my lord, am I, my lord, not to have a forum to ventilate the grievance? Now, my lord, Mr. Sen, my lord, when he briefly addressed your lordship, Mr. Chaudhuri, everybody, my lord, is, my lord, trying to, my lord, will tell your lordship, my lord, how bogus my matter is. Maybe, my lord, it's completely bogus, completely meritless. The fact that, my lord, I say that they suppressed this letter of 30th June, I should not perhaps have said it. But, my lord, if the court wants to say that this petition is not maintainable after, my lord, the passing reservation of orders, court will say that. If the court wants to say I am under a specific time frame in terms of the Supreme Court order, court will say that. So, my lord, what reason the court will supply, my lord, for not entertaining a petition at all is, my lord, unknown to me, and, my lord, in the exclusive preserve and domain of the court. But, my lord, all that I'm saying is, my lord, I remember once, my lord, and I'll digress a little with your lordship's permission. My lord, Mr. Prithij Bagchi told me, I am not scared of anything in the world, I am scared of 75 paise. Because that at that point in time, my lord, that was the stamp to be affixed on a interlocutory application. So he said, anybody can come and file any application, the judge is duty bound to hear it, however meritless it may be. So, my lord, really speaking, my lord, I will, my lord, not even try to, my lord, answer the questions with regard to the merits of my application.
Merits,
only one thing, my lord, kindly just have, my lord, I'll copy though, copy though. Unreported, to কিভাবে দেবো আর?
দাদা এটা দেখিও না, নাম দেখি গন্ডগোল হয়ে যাবে।
জুনিয়রই বলছে না দেখাতে।
See the cross title, please.
যেটা বলছি তুমি ওরকম ভাবে পড়ো, আমার আগেই দেখিয়েছি নাম শুধু না।
My lord, this is of course, my lord, I must, my lord, at the very outside point out, my lord, single bench, my lord, of Karnataka. But, my lord, it borrows, my lord, from Supreme Court. That's why I am emboldened to show it.
Mr. Shah, the Code of Civil Procedure is applicable here also.
The Code of Civil Procedure, my lord, my lord, my lord, I'll tell you, lordship.
Yes or no? Whether
yes, it will be applicable unless it clashes with the IB code. IB code has a non-obstante clause, section 238, says, my lord, that anything, my lord, which is contrary to the IB code will not apply. Otherwise, it will apply. Of course, it will apply.
Yes.
And there are, my lord,
Here I have not seen this. I think from the decisions and so some is order 18 rule 17 because the decision on order 18 rule 17 has been relied upon,
Yes.
and another order 9 rule 7. Any contrary provisions in the IBC with regard to that. So those will apply.
Apply.
Yes.
Those will apply. IBC, my lord,
Rule 7, Mr. Saha,
my lord,
till which stage it applies?
my lord, I would have, my lord, I will address your lordship briefly on that as well, my lord, very briefly.
So you are on order 9 rule 7 at any point of time you can come up. My query to you is till which stage order 9 rule 7 is applicable?
my lord,
7 বলছেন কেন?
আমার বইটা দেন।
না একই জিনিস দাদা, আলাদা নেই, একই আছে।
Yes. You have a different book, Mr. Chatterjee. Different civil procedure code.
My lord, let me read order 9 rule 7 and then I address your lordship. Procedure when the defendant appears on the date of adjourned hearing and assigns a good case for previous non-appearance. Now, my lord,
yes, so it starts with
yes, where the court has adjourned the hearing of the suit ex parte and the defendant.
That clause. It's order 9 rule 7 will apply when a date has been fixed for hearing or adjourned.
Yes.
Order
No,
9
my lord,
rule
here,
7
my lord,
is applies to the first date of appearance. Thereafter is order 17. It's adjourned.
Yes.
Show me in your case, in order to apply order 9 rule 7, it has to be an adjourned date of hearing.
my lord, I am making
Until which stage hearing can be said to continue.
Exactly.
my lord,
Please
may I
address me on that.
my lord, may I, my lord, just my lord, digress a little bit, I'll come to this. My lord, respectfully, in my case, my lord, since my lord, it has been reserved for orders, my submission.
Stage for hearing, or it's a stage post hearing.
My lord, I am coming to that. My contention is, very well, my lord, let me just, my lord, let me start by, my lord, inviting your lordship's attention. My lord, your lordship has the a Companies Act though. Companies Act একটা নেই? My lord, let me hand up the Companies Act.
Yes, Mr. Chatterjee. Your junior wants to make some submission.
No, no, কর না। আরে তো দেখতে চাইছে জজ, তাই জন্য, আর কোনো কারণ নেই।
Yes.
I was wondering why your lordship is referring to.
So the judgment which you,
Absolutely
Mr.
correct.
Shah placed,
Absolutely correct.
seen that while going through that, I found those order 9 rule 7 provision has been quoted and
Cited for some other reason.
For some other reason.
What for you are citing?
My lord, I am citing this, my lord, because it says, my lord, your lordship,
under the impression that
Because of the name, nothing else.
no, my lord, kindly see the issue in paragraph 4. Kindly see the issue in paragraph 4 of this judgment.
Yes.
Kindly see the issue in paragraph 4 of this judgment. On the other hand, lordship has it, my lord?
Yes, yes.
On the other hand, the learned counsel for the respondent plaintiff refuted such argument, placing reliance on another decision of the Supreme Court in Veluswamy, and contended that there is no statutory bar against receiving an application after the suit is heard and reserved for pronouncement of judgment. This is exactly what is our case. Heard and reserved for pronouncement of judgment. And therefore, the learned trial court could have received the subject application. Then, my lord, kindly come to paragraph 6 where he frames the issue.
Have you got 2011 volume 11?
Yes, I've got. After this, I'll show it.
Yes.
Paragraph 6. In these circumstances, the only question that survives for the court's consideration is whether the trial court erred in receiving an application for appointment of commissioner after hearing was closed and matter reserved for pronouncement of judgment and later listed for clarification. Then, my lord, next paragraph. The Honorable Supreme Court in K. Veluswamy versus Palaniswamy, while listing the circumstances under which the provisions of section 151 CPC could be exercised, has enunciated that the restraint which the courts practice in receiving the interlocutory applications after the arguments are concluded is a matter of convention, and this convention cannot be applied as a straitjacket formula when exceptional or extraordinary circumstances justify the receipt and consideration of such application. And in those circumstances, the courts can receive such application to meet the ends of justice and to prevent abuse of the process of court. Relevant paragraph is as follows. This is the Supreme Court's paragraph. I have the Supreme Court also. The learned counsel for the respondents contends that once arguments are commenced, there could be no reopening of evidence or recalling of witnesses. This case was only on recalling of reopening of evidence. The contention is raised by extending the convention that once arguments are concluded and case is reserved for judgment, the court will not entertain any interlocutory application for any kind of relief. The need for the court to act in a manner to achieve the ends of justice, subject to the need to comply with the law, does not end when arguments are heard and judgment is reserved. If there is abuse of the process of the court, or if interests of justice require the court to do something or take note of something, the discretion to do those things does not disappear merely because the arguments are heard either fully or partly. The convention that no application should be entertained once the trial or hearing is concluded and the case is reserved for judgment is a sound rule, but not a straitjacket formula. There can always be exceptions in exceptional and extraordinary circumstances to meet the ends of justice and to prevent abuse of process of court, subject to the limitation recognized with reference to exercise of power under section 151 of the code. Then my lord, kindly have paragraph 9. In the first of these judgments, the Honorable Supreme Court has declared that the restrictions practiced in receiving applications after the suit is reserved for pronouncement of judgment is a convention, and such convention cannot be applied as a straitjacket formula, and that where the facts and circumstances justify, courts can receive applications even at a stage to meet the ends of justice and to prevent abuse of process of court. And in the second of these judgments, the Honorable Supreme Court, considering the provisions of Order 9, Rule 7, which enables a defendant to appear when court has adjourned the hearing of the said suit ex parte, has concluded that this situation that is contemplated in Order 9, Rule 7 is different from the situation where the suit is closed for judgment after the conclusion of hearing, and declared that the defendant in that case could not have claimed that the court has adjourned the hearing as contemplated under Order 9, Rule 7.
Yes.
And then, the conclusion, paragraph 11. Hence, it is held that the Honorable Trial Court Judge could in law receive the application being I number so and so by the plaintiff for appointment of court commissioner after hearing in the suit was closed and was reserved for pronouncement of judgment, and as such there is no illegality or irregularity on that score in the impugned order. In view of the submission, so and so petition impugned order in those questions is answered above, nothing survives for consideration. Now, 2011, volume 11.
That's on Order 18, Rule 17.
That's on Order 18. 151. And 151.
Yes.
And on 151.
Order 18, Rule 17 is the court's power.
My lord, I think I've read up mine.
Yes, that will help me. Order 18, Rule 17A, after deletion, court has the power under 151.
My lord, kindly, my lord.
So, you can straight away kindly come to paragraph 19 of that judgment.
15.
19.
Yes, 90. Copy there. Paragraph 19, my lord, at page 285.
Yes.
we may add a word of caution. The power of the court under section 151 or order 18 rule 17 of the code is not intended to be used routinely merely for the asking. If so used, it will defeat the very purpose of various amendments to the code to expedite trials. But where an application is found to be bona fide and where the additional evidence or oral or documentary will assist the court to clarify the evidence on the issues and will assist in rendering justice, and the court is satisfied that non-production earlier was for a valid and sufficient reason. Here we say we didn't have the document. The court may exercise its discretion to recall the witness. Here, my lord, not asking for recalling. It's not a trial stage.
That is why I'm saying,
yes,
there, when I've seen 2011 volume 11, that's the recalling of witness at what stage?
Lordship. My lord, here, my lord, that
distinguished 2009 volume 4, where it says not to fill up the lacunine evidence.
Yes,
considered, and it says if it is in the interest of justice,
my lord, I'll tell
for
you,
rendering justice, it can be at any stage.
My lord, that is, my lord, the test. If your lordship feels, or if, my lord, the tribunal feels that, my lord, I have made a malafide application, but the tribunal has not come to that finding. So today I will not even, my lord, address your lordship as to, my lord, just see, please, how bona fide I am. I showed you that letter, my lord. I may not have showed you, but I am showing you that letter, my lord, only to impress upon your lordship, my lord, to, my lord, cross the first hurdle, that, my lord, দেখাচ্ছি ওই প্যারাগ্রাফটাই তো পড়লাম তাই না 18টা পড়ব না 19টা পড়লাম দেখাচ্ছি so my lord, only to cross the hurdle that, my lord, your lordship will, my lord, find during the course of the arguments of my learned friend, my lord, they will not, as they cannot, make a statement that the 30th June letter was produced. It was considered. If they can do that, my lord, I have no case to argue.
Anything more?
So, my lord,
anything more?
Only, my lord, one paragraph, my lord, Mr. Chatterjee is insisting, my lord, that I read and trouble your lordship further with. My lord, kindly take, my lord, just, my lord, paragraph 15. Let me read it. 6 and 16. My lord, paragraph 15 is the same paragraph which has been quoted verbatim, my lord, in the Karnataka High Court judgment. This is, my lord, the same paragraph. Learned counsel for the respondent contended once arguments are commenced, there could be no reopening of evidence, recalling a witness. This contention is raised by extending the convention that once arguments are concluded, the case is reserved for judgment. The court will not entertain any interlocutory application for any kind of relief. The need for the court to act in a manner.
Tribunals have power under 151.
No, tribunals have power under my lord, Rule 11. I have handed up the rules to your lordship.
No,
I showed you 13.
Under section 151.
Yes, same inherent power. Inherent power, my lord, Rule 11.
11 is there.
It has its own powers under 151.
My lord, Rule 11, my lord,
more or less parameteria with.
Absolutely parameteria. Absolutely parameteria.
151 doesn't grant the power, it says it.
So, my lord,
151.
that is, my lord, Palana Swami's case, my lord, Supreme Court says that, my lord, 151, if there is a power, whether it is, my lord, for or against, implied or express, then you cannot use a provision which is already there. But if there is no provision, then, my lord, 151, my lord, that is the. So, my lord, kindly see, my lord, this is, my lord, my lord, placetum D onwards. Placetum D onwards. This contention raised by extending the convention that once arguments are concluded and the case is reserved for judgment, the court will not entertain an interlocutory application for any kind of relief. The need of the court to act in a manner to achieve the ends of justice does not end where arguments are heard and judgment is reserved. Does not end where arguments are heard and judgment is reserved. Kindly see, my lord, this, my lord, particular line, this by the Supreme Court. The need for the court to act in a manner to achieve the ends of justice, subject to the needs to comply with the law, does not end when the arguments are heard and judgment is reserved. If there is abuse of process of the court or interests of justice required the court to do something or take note of something. Here I am asking him to take note of this letter.
Yes.
The discretion to do those things does not disappear merely because the arguments are heard either fully or partly. My lord, I will, my lord, with your lordship's kind permission, my lord, refrain, my lord, from, my lord, going into, my lord, the details and merits of the case.
Kindly give me 5 minutes.
I will give you. He has not
My
completed.
lord, kindly allow Mr. Chatterjee, my lord.
We all have to finish by 3:30. He's had 1 hour.
3:30.
4:30.
I have a division bench.
Oh, Lordship of the bench. Milord, please, Milord, they can't take up 80%
Yes,
of
Milord, I will also take only 5 minutes just to point out, Milord, on maintainability, I will not urge.
same thing.
My lord, kindly give Mr. Chatterjee 2 minutes.
Lord, can he takes up this judgment once?
Yes.
They had a copy there? Delhi High Court.
Which judgment?
No, this, your Lordship has seen the Supreme Court judgment. Here, the Executive Judge have given. Here, the Delhi High Court, my lord, kindly sees paragraph 19. I'm sorry, my lord, your Lordship need not trouble my lordship with all that. 22. It would also be useful to refer to Order 6, Rule 17. This again refers to a stage of the proceedings and not the hearing, as in Order 9, Rule 7. Thus, an application for amendment may be filed by either of the party at any stage of the proceeding. Of course, if the trial is commenced, the court may not allow such amendments unless there was due diligence. As noticed herein and before, the stage of the case may be at the time of pronouncement as well as beyond in the form of an appeal. So, at every stage, my lord, the litigant has a right to file an appeal, file an application. And the court, it is duty bound, my lord, to consider it. We are not on merits before your lordship. We are only on consideration, nothing beyond that. Good, bad, indifferent, my lord, an application has been filed. The law allows me to file an application. The other side doesn't have the right to say that I can't file an application. And it's the duty of the court to find out the truth. My lord, I go back to Justice Dalveer Bhandari's judgment. We are only on that. Nothing else.
Yes. Yes,
Lord.
Only one thing I
5 minutes. Enough, Mr. Shah.
Yes.
Please. I'll take 5 minutes.
Judge says enough, not you.
My lord, only one date. I just want to give one date. My lord, the Supreme Court's order is 16th May. Is 16th May.
Page.
My lord, that is at. Bolo page.
Hello, hey, page number.
130.
130, my lord.
Yes.
That order is, my lord, dated 16th May. And it said, my lord, that, my lord, proceedings must be completed within 60 days. That your lordship will find. My lord. Yes.
But that doesn't take away my right to file an application.
My lord, I am just clarifying it. Just, my lord, clarifying. It says within 60 days.
6 weeks.
6 weeks, I'm sorry. 6 weeks. Now, my lord, that is within a period of 6 weeks from today. Kindly mark from today. Now, my lord, 6 weeks from, my lord, 16th May would, my lord, take us, my lord, to the end of June. To the end of June. Now, my lord, kindly make a note that 30th June was the date on which the hearing commenced. Before, my lord, the special bench. By which time this period had already expired.
30th June hearing commenced.
No, 30th June bench constituted.
Bench constituted.
Yes. My lord, hearing commenced on 3rd July. 30th
3rd July hearing started.
And
the hearing concluded.
Hearing concluded on 10th and 11th. 10th,
11th. 11th is the last.
Yes.
11th is the last date.
Amader application at 10.
My lord, there are two orders. One order is, my lord, 10th. One order is 11th. So, my lord, hearing concluded, let us say on 11th July.
Yes, 11th of July.
My lord, all that I am showing is that, my lord, our application concluded on 10th July. All that I am showing is, my lord, that, my lord, from 16th May, 6 weeks expired, my lord, on 30th June, around 30th June. So, my lord,
then do you want to suggest that it can?
I am only trying to suggest. My lord, I am only trying to suggest. My lord, I am only trying to suggest that, my lord, if they say that the Supreme Court order prevents me from taking up this application, then, my lord, the initial application could also not have been taken up. That's all that I'm saying, my lord. I am the last one. I have myself filed an application, and I am here, my lord, shouting, my lord, saying that, my lord, my application is not being entertained. So I am by no means trying to suggest that the period is over and you can't take up. I am only trying to say the sauce for the goose is sauce for the gander. If all these applications could have been taken up, now, my lord, they will say one thing. They will say the order was communicated much later. My lord, that does not, my lord, hold any water, because, my lord, the order says from today. So, my lord, all parties knew about the order. If it was communicated late,
Please, my lord, please. My lord, please have a look at the number of applications filed by this party during the CIRP. My lord, just the number 9.
Mr. Chaudhary, who are you representing?
My lord, the resolution professional.
Opposite party number?
1, my lord. 2.
No.
No, 1.
One goes there. And you should be fair, remember that.
1, no?
1.
I'll just check, my lord.
No, I think 2. 1 is COC.
Now, my lord, I'll just tell your lordships why this should be dismissed with exemplary costs. 9 applications filed by this party out of the 116 applications filed to ensure that the main matter cannot be heard. My lord, first bench, my lord, the president took the matter away from the first bench. Second, my lord, the bench was passing orders, even despite the Supreme Court order directing hearing of the plan approval application and finishing the matter. The bench was not taking up that matter. Ultimately, my lord, the bench, my lord, recused when, my lord, nothing else was left. Then, my lord, the NCLT president, my lord, formulated a special bench. Your lordship has seen that, my lord, notification. My lord, please have a look at that notification once. This is at page 28.
Page
28.
I think this is the same page as Mr. Shah has also.
Yes.
pointed out.
This is
that
after
page first.
everything, and this after the Supreme Court order, when
Page 148.
page 148.
Yes.
148 is the notification.
Yes.
He
That's
wants
what
to, I think, show the order by which, my lord, it was released.
the notification.
he wants.
Notification 148.
Constitution is 148.
Notification 148.
So it has been annexed twice.
Yes,
So,
so
we can
I'll read it for your lordship.
Yes.
Following matter was pending before 2 learned judges. The Honorable Judicial Member is recused from hearing. Honorable President is pleased to constitute a special bench of the National Company Law Tribunal to hear the aforementioned matter. And special bench at NCLT Kolkata is, my lord, done. Constitution of bench is as per section 4193 of the Companies Act 2013. My lord, please have a look at section 4193 of the Companies Act. Gives the power to the president of the NCLT.
Companies Act দিয়েছি জজকে
My lord,
এখানে আছে
4191, my lord. I'll just hand up to your lordship.
দিয়েছি দেওয়া আছে
Yes, 4191.
Yes, my lord. 419. Constitution of benches is by notification specified by the central government. And, my lord, then your lordship will see the other my lord, provisions, my lord, which are given. Now, my lord, please see 4193. Powers of the tribunal shall be exercisable by benches consisting of 2 members, judicial member, technical member, provided it shall be competent for the members of the tribunal authorized in this behalf to function as a bench, such and such. And it ends, my lord, as the president may by general or special order specify. The number 1. So this is a bench, my lord,
which is designated as the special bench at Kolkata, at NCLT Kolkata, by the President. And it has been directed, please see paragraph 4, honorable members shall sit physically at the NCLT Kolkata new premises from 3rd July 25 regularly and complete the hearing. And NCLT Cuttack bench will be by video conferencing. Hearing was completed. 2 weeks the bench was here. Whole mornings, my lord, this hearing was done. Then from 4 o'clock in the afternoon it was done. All those 100 applications were disposed of. Plan approval was taken up, heard, reserved for judgment. Bench went back to Cuttack because it's the same constitution of the Cuttack bench. Now thereafter, my lord, this application is filed. After, my lord, lapse of 10 days, this application is filed. And attempt is being made to mention the matter before the Cuttack bench. Cuttack bench is not special bench at NCLT Kolkata. My lord, when your lordship, my lord, takes up some other determination, my lord, in Jalpaiguri or my lord in the Andamans, I can't mention a Kolkata matter.
I will remember that, Mr. Chaudhary.
Yes. My lord, this is worse. This is not even, this is another bench of the same tribunal. It's not possible. So what is to be done? You have to approach the President for Constitution. Now, my lord, that they have issued a letter to the President, which is, my lord, at page 145, and then again, my lord, at page 152. President functioning from Delhi. So, my lord, if you are aggrieved, firstly you can apply for transfer, you can apply for any direction you want. I'm not reading the letters to save time.
Yes.
So go to Delhi. As your lordship said, go mention the matter. Mentioning means upon notice, not, my lord, somebody appearing from here virtually trying to say something without the other side knowing.
Yes.
So the remedy, my lord, for a hearing lies before the President in terms of section 419 of the Companies Act, because of the fact that he is the person who will decide, my lord, the roster, and he has to ask the Cuttack bench to again function as the special bench Kolkata.
4194.
Because special bench Kolkata was from this date till conclusion of hearing. That's happened. Special bench has gone back. Now you have to approach the President to get the special bench to sit again. And you've gone written letters, your remedy lies there. Not, my lord, before an honorable court, my lord, which is not really in season of the matter, so you can get away with it. Now, why do I say they want, my lord, to come to your lordship to get away with it? Because otherwise they will not get away with it. One example. What is the excitement, my lord, in the matter? There is a letter. My lord, please come to page 103. I'm not getting into merits. It's because of this letter that this whole, my lord,
yes, 30th of June.
30th June. Now, my lord, see their application, which is at page 50. Please come to page 66. At the top, page 66. Application is being filed seeking appropriate orders for rejection of the plan, and it is necessitated due to subsequent discovery of a letter dated 30th June 25.
Yes, so that
yes,
was
now, my lord,
30th of June.
Yes, now take page 97. At page 97 is an additional written notes of argument in view of subsequent discovery of UNESCO's letter dated 30th June 2025. In an IA which has been reserved for orders.
See the last paragraph, page 97.
And my lord,
filed.
Yes, it's been filed on 16th of July.
Mr. Shah's client.
Yes.
These
Court is in season of the matter.
these ideas have been heard and disposed of. All these ideas have been 97.
When it was filed?
My lord, it's dated 16th July 2025.
This is an annexure to my application.
Right.
Whatever it is, I am just bringing something.
Note was filed on 9th of July. Malad, this written note was filed on 9th of July. The hearing in 21 was concluded on 10th. Can this
This
written
additional written note
Yes,
filed
9th,
when?
9th of July.
Malad, not filed. It is annexed. Malad,
No,
no, no, let me see. It
Mr.
is
Shah,
annexed to my.
Mr. Shah, you get your chance.
This is not NCLT.
Yes.
Now, my lord. Now, so the court, my lord, is in cessation of the matter. It is also, my lord, utterly irrelevant. Now, my lord, please take the Supreme Court order at page 130.
So, Mr. Chaudhary, only one thing.
Yes.
What is the date of filing of this written
Miller,
notes?
please see, my lord, the notes of argument at 97.
Yes.
It is signed, my lord, and the second page filed by Victor Chatterjee, advocate for the applicant, dated 16 July 25.
And see the next page, sir.
And please see the next page.
It's there on
Yes.
the famous photo on 10th of July.
And Lord, page 100. This shows, my lord, filing date on 10th July.
How can it be? If it
Sir,
is
100
signed on 16th of
16th July, and below it shows document up filing date. This must be something else in that case.
I think
Whatever
it's
it
not
is, whatever it is, his notes of argument is before the court.
102.
My lord, I shall clarify, my lord. The notes of argument which Mr. Shah's client has filed, kindly take this page. The notes which they have filed is at page 37.
No,
And
no.
specific point, yes, kindly, Mr. Chaudhary, I'll just show this.
Oh,
One,
Please, he will be getting your
Mr. Please, 102.
Yes.
This is the portal. Filing date is 11th July 25.
Yes. And in 20.
Chaudhary, how do I know that this is the written notes which was filed on that?
Because he has disclosed it. He has disclosed it.
It's his written note. We are not
Barkan,
privy to
amendment
this.
Barkan.
We are not privy to this. My lord, he has disclosed it. And we are not privy. He has
Now,
disclosed it.
Millard, 102 Millard shows the IA filing number. Lordship will see Millard the IA number here.
This is IA is that application.
Yes.
IA is the application.
His application, he files a note, page 102.
Yes.
Filing details shows.
Paragraph 13. Kindly see paragraph 13 of the petition. Page 81. Paragraph 13. In page 81, what he wants your lordship to be heard.
Accordingly, applicant promptly filed an additional written note in IA such and such, bringing on record the letter dated 30th June.
13, 1-3.
Yes. At page 81. This is his pleading in his proposed application. 81.
81, my lord, is part of
Paragraph 13.
Yes. Accordingly, the applicant promptly filed an additional written note in IA number P such as bringing on record the letter dated 30th June 25 issued by INSCO and the minutes of the 42nd COC meeting held on 14th July. He admits this himself.
He says, show me one document I didn't know. But this is not placed before the court.
This is
the INV 25 which he wants to be heard.
So this is the application which he wants to be heard. Now, my lord, please come to the, I'll take 2 minutes. Come to the Supreme Court order. Supreme Court order, my lord, this is third, after 3 rounds in this matter before the Supreme Court passes an order at page 131, bottom, my lord, paragraph 19. The reconsideration is undertaken accordingly to paragraph such and such of the majority judgment. COC shall consider, my lord, it's serious, shall consider for approval the resolution plan of INSCO within a period of 2 weeks from today. The COC and the adjudicating authority are directed to complete the CIRP, directed to complete both under such and such within a period of 6 weeks from today. After this, my lord, what happens? Court was bound to hear the matter. Court, my lord, instead of taking up the plan approval, suddenly, my lord, took up an application filed by Mr. Shah to remove the RP. And my lord, remove the RP, which was also set aside by NCLAT ultimately. But when the court removed the RP, what happened was that the process got stayed, Supreme Court order got frustrated, and the delay. Ultimately, my lord, when we wrote, my lord, to the NCLT president that this has happened, Supreme Court order is there. The NCLT president, my lord, constituted this bench to come to Calcutta and hear the matter, heard all of us. In the middle of the hearing, RP, my lord, the order, my lord, was set aside. We finished hearing. They, my lord, thereafter filed notes. Notes, my lord, has this. Now, after 10 days, it's now very clear the order is coming. Maybe Monday, maybe Tuesday, order is now going to come. Now, they want to, my lord, delay that by showing pendency of an application. So they go to Cuttack and they mention the matter. We opposed and said that this is not the bench. I appeared and said, this is not the bench. You can't do it. Then they suddenly, my lord, come before your lordship saying all of this. Now, may I give your lordship, this is a very serious issue. Now, on law, my lord, may I show your lordship knows this very well, Arjun Singh's judgment.
Yeah, Arjun Singh.
My lord, may I just hand up? My lord, 1963, AIR 1964, Supreme Court 993. My lord, please come to paragraph 20. Paragraph 20, my lord, page 16 of the print. Middle of the page, just before, my lord, paragraph 21. In the middle of the page. In the present context.
Paragraph
when 21. My lord, please see the page number right at the top, my lord. This has to be page 16.
Yes.
Continuation
Yes.
of paragraph 20.
Yes.
Middle of the page. There is a 1 and 2. My lord, in the
Two
present.
stages.
Yes, my lord.
2 stages. That is
Yes.
Yes.
about.
And when hearing is completed, parties have no further rights or privileges in the matter, and it is only for the convenience of the
Shah this. There are 2 stages. What can be done after this?
after that. Now your lordships have also said under, yes, under, my lord, in extreme cases, my lord, when interests of justice demand, in exercise of inherent powers, your lordships have carved out an exception, which is the judgment, my lord, your lordship referred to, which was cited. But in paragraph 19 of the judgment, where Mr. Shah stopped reading, the next sentence is very important. My lord, please see the next page.
No, this is different.
আরে দাঁড়াও ওইটা কর্ণাটকা না সুপ্রিম কোর্টটা দাও না যেটা জয়দা দেখালো হ্যাঁ প্লিজ সি প্যারাগ্রাফ 19 he stopped, my lord, but if it does so, it should ensure that the process does not become a protracting tactic. This is what is being done here. And also see, my lord, paragraph 15, which Mr. Chatterjee read. After placetum D, just before placetum E, if there is abuse of the process of the court, or if interests of justice require the court to do something or take note of something, the discretion to those things does not disappear merely because arguments are heard. My lord, it's the other way around. Here, my lord, keeping this pending or asking the court to reconsider or consider this application will amount to abuse of process, because then the court will not be in a position to deliver a judgment which it is about to do in terms of a Supreme Court direction. And the court is already in session of the matter. Now, my lord, 2 dry issues of law. Number 1, if I may ask myself the question, who is to ensure hearing of this application? President of NCLT. President of NCLT has his seat in Delhi. You are unhappy with the functioning of the President of NCLT, go to Delhi High Court. This is Article 227. So 220 territorial jurisdiction. Matter may be here, but right of directing hearing and constituting a bench lies with the President. Go to Delhi High Court. This honorable, because he's not challenging, my lord, the real matter. He is challenging non-hearing of the, no opportunity to hear the application. Your Lordship remembers, the notification. Notification was special bench from such and such date till conclusion of hearing. Conclusion of hearing has happened, reserved for orders. Now, even if that bench wants it, cannot come. Till, the president tells them to come again. So you have to approach the president, which you have. And if you are aggrieved by the fact that the president is, not doing something, then you have to approach the Delhi High Court. Because president is within the territorial jurisdiction of the Delhi High Court. Number 2. So many times, when we
Mr. Chaudhary, how much time you?
to 1 minute, because Mr. Thakkar is here, he has to be heard.
I have a
Just
bench
1
at-
minute.
I have a bench at 3. That's the problem.
Just one.
Mr. Shane also has to be given.
Yes, but I will have to say something. 2 minutes, but I will not take my. I will. But he has already said most of the submissions which I was supposed to. I do not want your lordship to be take this matter on Monday. Let it be concluded, my lord. Because our points are more or less common. I just add 2 things and I'll conclude.
Just 2 minutes. Just let me be very clear. Next point is Arjun Singh has been followed by NCLAT.
And Rajasthan High Court.
And
Yes, Rajasthan High Court.
The NCLAT. Rajasthan High Court is not NCLAT is important because it decides, my lord. Hey, copy though. It decides, my lord.
So there it has been held that after resolving
Cannot be heard.
Where
Cannot.
is- Which paragraph?
My lord, please come to paragraph 13. I'm sorry.
13. Yes, I've got that paragraph 13.
Yes, this is Justice Ashok Bhushan's judgment.
So this is merely reiterating Arjun Singh.
Yes.
Yes.
And NCLAT has held this. Looking into code.
Has to be because
Has to
Supreme
be.
Court judgment everywhere
Yes.
is binding,
And you are-
provided the principles apply.
Yes. And
Provided that apply.
Section 424 of the Companies Act, the principles apply.
Where is that?
Of the Companies Act.
It is not bound by only natural justice. Actually, Judicial the Companies Act
Principles.
shall not be bound by the procedure.
Yes, it says, my lord,
Only natural justice.
tribunal, appellate tribunal, while disposing. My lord, 424 lordship has, my lord.
Yes.
Tribunal, appellate tribunal, while disposing of, etc.
Bound by the
shall
procedure
not-
put down in the Civil Procedure Code.
Shall not be, my lord.
Yes, shall not be bound.
Shall not
Shall
be
be
bound.
guided by the principles of
Natural justice. And subject to
Their
whatever.
own rules.
So basic principles, my lord, for natural justice and for procedure will be followed. And this is, my lord, an IBC matter. There under the Insolvency Code, the NCLT is appointed as the adjudicating authority. That's how it takes up the matter. So that is, my lord, that's under one of those sections, my lord, 6 or 7. So this is the matter. This is pure abuse of process of law. Kindly, my lord, do not entertain it because they will use this to delay delivery of a judgment over 120 misconceived applications and the plan.
Mr.
But please,
Thakkar,
this
Mr.
is
Shane, do you have to make any submissions?
Yes, but only 1 minute. My lord, may I just say?
I will just take 2 minutes. Your Lordship kindly takes his prayers once.
Yes.
How the malafide will come out from his prayers itself. Kindly see page 20. He seeks setting aside 2-0. Malafide comes out, kindly see page 20.
Yes.
Your Lordship will see the cat comes out of the bag. Kindly see about the 6 lines. Issue a rule calling upon the opposite parties to show cause as to why the impugned order dated 10th July 2025. And your Lordship sees what the order of 10th July 2025 is. It just records conclusion of hearing and orders being reserved. Kindly see the order dated
Page
10th July 2025 is at page 29. Kindly see page 29. Kindly see, my lord, I appear for INSCO, which is at the top, my lord, the successful resolution. Then kindly see, my lord, Mr. Joy Shah, applicant for IA 21. which is the application in which he filed the supplementary notes. And this is the only order which is made. Hearing is concluded and reserved for orders. Kindly see serial 6 at page 29A.
Yes.
This is the order which he seeks setting aside of. The purpose is that you reopen the whole hearing. That is why he seeks setting aside of the order. There's nothing else in this order. There is no adjudication. All applications have been heard. Hearing is concluded and pending matters on 11 July. So what is reserved is, my lord, INV 21, which is reserved for orders. He seeks reopening of this. Otherwise, there's nothing else in this order which affects him. This is the whole malafide. Now, second, my lord, this whole point that I came to know of this now, I didn't know of this earlier. Your lordship has seen the supplementary notes. This he has taken as far back as on 9th of July. Kindly have page 35, please, my lord. Page 35. Kindly have page 35. He has taken this on 9th of July. Kindly see the application number at the top of the page, my lord. Intervention application number 21, which is his application. Yes. Page 35. Now kindly come to serial 8 at page 37. What Mr. Shah argued before your lordship cannot be a conditional contingent plan. Kindly see serial 8 at page 37. Sinnar plant rebuild cause in the plan makes the plan conditional contingent insurance claim. Then kindly see serial 4, emphasis supplied. Plan based upon money to be received from the insurance company is conditional in nature, thus bad in law. Please refer to the judgments. This point has been squarely argued by him.
That is what I said.
And this note, my lord, was filed on 9th of July, which your lordship will find at page 48. So it's not 16th of July. After conclusion of hearing, no, it is before conclusion of hearing. He's taken this point squarely and argued. Kindly see page 48. This note is filed on 9th of July.
Page 48.
Yes. Note filed on 9th of July. Conclusion of arguments, he argues this point threadbare in oral arguments as well as in written submissions. Now, Sudha Thakur.
Yes.
Now, my lord, in an IBC matter, kindly see the approach of the Supreme Court. How it says that even a 226 should not be entertained. Kindly see for violation of natural justice in IBC matters. And I'll show your lordship, my lord, what natural justice is all about. Kindly see paragraph 2 of this judgment. These appeals under 136 are against the judgment of the High Court of Karnataka exercising power of judicial review, interdicting the CIRP process culminating in the acceptance of a resolution plan by the Committee of Creditors in minutes of meeting dated 11 February 2020. Now kindly see the ground which was urged. Kindly come to paragraph 8, please, my lord. I'm not troubling your lordship with the full thing because you're short of time. The High Court, your lordship has?
Yes.
The High Court initially granted ex parte stay, directing the adjudicating authority to maintain the status quo, and finally by order dated so-and-so allowed the writ petition whereby appellant's resolution plan was set aside. Review petitions were filed by the consortium banks which were allowed on so-and-so, writs were restored. However, by the impugned order dated so-and-so, the High Court again allowed the writ petition and set aside the resolution plan, primarily on the ground that principles of natural justice are violated as 24-hour notice was not granted. Can you come to paragraph 4, my lord? The ground was, I was not heard. While the appellant contends that the second exactly same case, my lord, can you see paragraph 4? The successful resolution applicant contends that the second adjournment was convened after notice to all. Mr. Shyam Diwan, my lord, who was the writ petitioner before the High Court, has submitted that no such notice was ever received. In the meeting, a slightly revised, amended and restated resolution plan was considered, deliberated upon by COC and put to vote. Resolution plan is supposed to have been approved on so-and-so. So, my lord, his contention was that a revised plan has been approved without notice to me. Now, my lord, kindly see what the Supreme Court says. Kindly come to paragraph 12. Further, it is also an admitted fact. Further, it is also an admitted fact that on 6th October 22, R1, who is the writ petitioner before the High Court, moved an interlocutory application before the adjudicating authority seeking rejection of the resolution plan filed by the appellant. The grounds taken in the interlocutory application are the same as those in this appeal. It is not as if the High Court was unaware of R1 settling the statutory remedy under the code. At least on this ground, the High Court should have relegated R1 to the procedure under the code and permitted him to continue the remedy that he.
Paragraph 13 is the.
13 is the crux of the matter. 13, 14. High Court
13 and 14
14.
and 15, my lord, complete code.
The complete code. The supervisory, kindly see 15, my lord. I'm sorry, it's highlighted. Apart from the High Court should have noticed that the IBC is a complete code in itself, having sufficient checks and balances, remedial avenues and appeals. Adherence of protocols and procedures maintains legal discipline and preserves the balance between the need for order and the quest for justice. The supervisory and judicial review powers vested in High Courts represent critical constituencies.
The provision of appeal also.
Yes, NCLT, if the plan is rejected, they will go up.
Never nothing. 1 minute, kindly.
And who is intervention application?
Please, what made your submissions?
Please, we've had a chance for 2 hours.
Who is he?
Yes, yes.
600
Please, please. So even the critical constitutional safeguards demands a fit case for High Court to interdict CIRP proceedings under the IBC. Now, Your Lordship, Mr. Chaudhary has shown Your Lordship one of the rules which say Code of Civil Procedure not applicable, only natural justice applicable. Kindly see, my lord, what is natural justice? It's not.
Thakkar, how much time?
I'm finished. Just one decision. Just one decision. Kindly have natural justice. Yeah. Hand over.
My points have been all taken care of, I find.
All right.
Judgment down, mera. Mera copy. Kindly see, natural justice is not an unruly horse which you can press into service to do everything. Oh, kindly have, kindly,
আমার jurisdictionের কথা বলছি।
Kindly come to paragraph. Kindly give me 1 minute, my lord. I handed over my copy.
Paragraph 13.
Yes, 13 and the conclusion paragraph, my lord, 19.
Yes.
My lord.
Unruly horse is paragraph.
Yes, 13, my lord. Did not inquire natural justice. Now, my lord, kindly see. Natural justice is no landmine, judicial cure-all. If fairness is shown by the decision maker to the man proceeded against, the form, features, and the fundamentals of such essential processual propriety being conditioned by the facts and circumstances of each situation, which of natural justice can be complained of. Unnatural expansion of natural justice without reference to the administrative realities and other factors of a given case can be exaggerating. It can neither be finical nor fanatical, but should be flexible yet firm in this jurisdiction. Should be held below belt, that is the conscious. Then kindly come to paragraph 15. These general observations must be tested on the concrete facts of each.
Paragraph 15.
13 and 15. If the totality of the circumstances satisfies the court that party visited has not suffered from denial of reasonable opportunity, the court will decline to be punctilious or fanatical as if the rules of natural justice were sacred scriptures.
All right. Anything more?
No, my lord, that IBC judgment and this, your lordship sees.
Want to give reply?
Well, I was there, my lord.
Then I'm keeping it on Monday.
Kindly not keep it on Monday. Kindly not keep it.
I have a bench.
The only thing is, in the next 2 days, if something happens, we will be completely wrong.
Concluding.
No, my lord, there is nothing, my lord, which will happen. Your lordship can make it CAV.
Hearing concluded.
Kindly make it
CAV, my lord, they'll come with another application.
Kindly make it CAV, my lord, hearing concluded.
There is no bar, in coming up with any affidavit of service.
যা আমাকে বলতেই হলো না।
CAV করে।
For the appellant, Miller. Led by Mr. Urijit Bordhan, he is appearing online, Miller.
Now there are 3 review applications, Miller.
Yes.
Miller, 3 review applications, Miller. But I was the writ petitioner.
Yes.
But the single judge held in my favor, Miller. Thereafter, Miller, the division bench, Miller, comprising Miller, Justice Tandon and Your Lordship, Miller, passed an order, Miller, against us. So that is the order sought to be reviewed. And may I put this way, Miller, this matter had travelled to the Supreme Court in an SLP, Miller.
Yes.
But thereafter, Miller, the SLP having been turned down, Miller. So, Miller, we are before the
For
review
the respondent.
That I appear for the
Mr. Ghosh.
heard out on a review. It's basically in guise of an appeal. Lordship, yes. Lordship has with a finding. Look at the grounds. It's like a memo of appeal.
But memorandum of review looks like a memorandum of appeal, Miller. That's what we have been taught.
Mr. Bordhan, yes, the format may be the same, but the
Yes,
ground
that's what Mr. Ghosh meant. That's what Mr. Ghosh meant.
wants to suggest that the grounds are the same. As in,
Mulad, I heard him, Mulad, with all earnest, Mulad. He said it looks like a memorandum of appeal. So, Mulad, it should look like a memorandum of appeal, Mulad, in all earnest.
Look at the grounds, Millard. They lot.
Mr. What is the error apparent?
Yes. Mulad, I will indicate, Mulad. Now, Mulad, there were 2 letters. The error apparent, Mulad, there is a letter dated 20th of March 2013, which was relied upon. But the letter which ought to have been relied upon is also a letter dated March 20, 2013. So the point of review is, the ground of review is the document that was relied upon and looked into while passing the order under review was not the document which was supposed to be looked into. That is the point of review, Mulad. Recollect there was a limitation, section 5 limitation, Mulad.
Section 5 is
allowed. Yes, that's allowed. Mulad, I've crossed that hurdle. I've crossed that hurdle, Mulad. Now, Mulad, what happened, I'll tell you, Mulad. Kindly, Mulad, takes my grounds 4, 5, and 10. Those are the grounds, Mulad, I'll be espousing.
No, the letter dated 9th of April 2013.
No, Mulad, 20th of March 2013.
20th of March, yes.
2013. Mulad, that would, Mulad, let me take the impugned order, Mulad, but I don't understand.
That letter was considered.
No, my lord. This letter was not considered. My lord, there were 2 letters. No, my lord.
Page 23 of the judgment.
Yes, precisely. My lord, this is where I want to be on, my lord.
Page
Kindly see page 20. My lord, kindly allows me to place it, my lord.
Yes.
What can be seen from the said resolution is that although the modification was approved, but it was to take effect from the date of issue of the office order by ECL appellant. By a letter dated 20th March 2013, the General Manager MC simply recorded the approval of the modifications to be incorporated in the General Terms and Conditions (GTC) on the basis of the decision of the functional directors taken in the meeting number such and such, dated such and such. Demol. By a letter dated 9/4/13, again for an approval for modification to be incorporated in the GTC was made, but no order was passed by the ECL appellant, substituting the modified escalation formula into the GTC/PTC. Even a letter dated 14/6/2013 issued by the ECL appellant indicates that the modified clause would come into effect from the date of issue of the office order by the ECL appellant. But thereafter, something is very important. Though Mr. Hirok Mitra Learned, senior advocate, has put much emphasis on the letter dated 23/2013 and 9/4/2013, that the ECL approved the substitution of the modified escalation formula, but it would be apparent and evident from the subsequent letter dated 14/6/2013 that it was so approved subject to further order to be issued by the ECL, indicating that the date from which it would take effect, there is the complete silence thereafter. Now, what has happened, I'll indicate. Admittedly, there were 2 letters. two letters dated 20th of March 2030.
Yes.
Now kindly sees page 181 of the stay application for once.
Now, Mr. Bordhan, what is your ground with regard to this letter? Take us
My ground, may indicate. Now there were two letters of 20th March 2030.
Yes. There were two
letters
of March.
Two letters. Yes, two letters. One letter was the letter which appears at page 181 of the stay application. Kindly takes it for one moment.
181.
Yes.
181 of the stay application.
The application ta kothay?
Sir, ওটা application, not the stay application.
MA. Understand correctly. Mr. Pal, please apprise my lord of the page number in the application.
FMA number 4689 of 2000.
FM. I stand corrected, my lord.
FMA number 4689 of 2000.
File test. FMA.
I have two copies of the SLP.
No, you have not filed any application in review.
There's an app. In review, there was there was a conditional application. But the records
in the stay application, you have not annexed that.
No.
FMA file is not here.
Sir,
the FMA file has.
over the copy of the SLPs. Those letters are there in the.
No. 1 second. Now there's one more issue, Malad. Now we say that this document, which has been relied upon in the impugned judgment, was not a part of the records as we filed it. Well, I tried my best in vain, but I could not lay my hands on the document on the letter 20th of March, which was relied upon while passing the order. The predicament today.
Then the file is to be brought. Where is that? Was
81.
20th of March 2013.
Yes.
Yes. Kindly see the FDs. See the FDs in its meeting held on 23/2013.
What I have, Miller, the earlier proceedings with me, Miller. Can Miller have filed in the appeal? I don't think it's part of this review.
I'm being led by Mr. Doctor. Mr. Doctor is there.
Actually, it's a review. We have to go through the records of the main proceedings.
Yes.
Records of the main proceedings. Yes, Mr. Bordhan. Oh, now.
Mr. Doctor is there.
Mr. Dotto or Mr. Advocate Jan?
Dotto.
Yes.
Now, Miller, the error is, Miller, if your lordships kindly have a look to the order, where the lordships were pleased to formulate the points. Just, Miller, to give your lordship, Miller, what is the error? But if your lordships may kindly have a look to the order under or judgment under review.
Yes.
Miller, your lordships were pleased to, Miller, frame the three questions, Miller, in the second page of the judgment under review.
Yes.
The appearing counsels argued on diverse points and initially cited innumerable judgments, but later on squeezed their arguments to the following points for consideration in the instant appeal. Firstly, a point has been taken by the appellant that the writ petition was not maintainable pertaining to the dispute arising out of the private contract and the interpretation of its clauses. Now, this point has been decided in my favor, that it is maintainable. Second point is the most important. Whether the escalation clause relating to the price of diesel incorporated in the additional terms and conditions was in fact valid stroke modified or not. And third is whether ECL was within its authority to withdraw, suspend earlier decision based on the report of the Central Vigilance Commission, and ancillary to it, whether the Central Vigilance Commission retains the power to pass any directions
on directions orders on ECL to do or not to do an act covered by the said contract. Now, these were the three questions framed. Point number one, in my favor, not
2 and 3 is really troubling you.
yes. Now, 2 and 2, please have a look, Milord, where Milord, your lordships were pleased to deal with 2. Milord, please take page number 22 of the judgment under review.
Yes.
We do not find any difficulty in finding out the meaning of the price of HSD for applying the escalation formula. However, we are poised with the question whether the escalation formula contained in the original contract was varied or modified subsequently. I pause here for a moment. But that was not the point. Where the point was that whether, Milord, or what is the rate at which there would be a escalation or de-escalation of the price. Milord, here is a case, Milord, where, Milord, I was executing a contract. For the purpose of executing the contract, I required...
Yes, Mr. Dotto, because this is a different composition.
Yes.
Brother was not there. You can give a brief.
Yes, yes, very briefly.
Facts,
Yes,
because
very briefly, I'll tell your lordship. What has happened is, Milord, to execute the contract, I required bulk diesel every day, several thousands of liters of diesel every day. Therefore, I entered into an agreement with the IOCL that IOCL will provide me a subsidized rate of diesel price. Therefore, the formula has been applied based on the subsidized rate of diesel. Now, from one point of time, the IOCL tells me that no, we cannot give it to you at a subsidized rate. You have to pay the normal rate. Therefore, when the normal rate was imposed on me, I had to purchase at the normal rate. Therefore, I went before the ECL authorities saying that, sir, from such and such date, I have to buy it at the normal rate. Milord, the ECL authorities had accepted my contention and they had increased the escalated, price. Escalated the price based on the formula from a date. That is the date of the rising of the price. It has a base date, it has a base rate. So from the base date, if there is a increase in the price, there will be escalation of price. From the base date, if there is a decrease in the price, there will be a de-escalation.
Now the rates are floating.
Now the rates are. My case was that because of this increase in the price, there has to be a change in the base rate to which they had agreed. And this is our case that I should get the base rate as decided by the ECL authorities. Yes. And the cause of action was that this decision was later on withdrawn. That withdrawal was the subject matter of the writ petition. Which went in our favor, before the Honorable Single Judge. Now, we were not, dilating before your Lordship, on the variation of the formula. Formula we are not concerned with. Formula A plus B plus C is there. Now the A or B got varied. Therefore, based on the same formula, we were entitled. But this is the case. This is the error. So therefore, two letters, where there is a confusion because I'll tell you, Roshi, why. Because there were two letters of the same date.
20th of March.
Therefore, the 20th March letter, which
are the two letters, because yes. One.
Yes, I'll give you a Lordship. First letter.
This is the FMA.
Yes.
So FMA page 181 is one letter dated 20th of March 2013.
Right.
So according to you, this is not the.
This is the letter which is in my favor.
Yes.
Kindly similar. 20th of March 2013.
Yes.
FD in its meeting held on 20th of March 2013 approved the proposal for base rate of HSD on bulk consumer price with effect on 18th of January 2013. Now this is the date on which I was told that no subsidized rate, you have to pay for, I buy it at the normal rate. Now this is in my favor. The other 20th March 2013 is, which is not there, my lord, on record. I need to, which is part of the SLP. If your lordship may kindly just have a look at.
If that was not there, how can it be?
What I was also not there. I was told again. It is not possible for your lordships to recollect also after such a point of distant point of time. But the other letter fell for consideration before your lordships in the judgment, which was not on record. This is the error. A 20th February, March.
So according to you, 120, 181 was not considered.
Yes.
And another
Another,
letter of,
yes,
where
letter,
is that letter?
yes, which is not part of the record, but possibly it was handed up to the court. Possibly, I cannot
Might
say
be because
yes, it's very difficult to recollect after such a long time.
Mr. Ghosh, you were there at that point of time. Mr. Ghosh, you were there at
No,
point.
I
You
was
were
not
also
there.
not.
I'm a new entrant.
So everything changed, Mr. Dotto. So it's a good ground for rejecting this. Councils have also changed. So which should not be done in review.
But this, again, if Justice Bhattacharya kindly recollects, in the other courtroom, this point arose. My learned friend was good enough to raise this point that with the change of counsel, there cannot be a review. But your lordships found that there were some merit to go into.
Section 5,
That was section 5.
Yes,
Section 5, lawyers ground was taken. So
lordships were became.
No,
I also did not.
Because that's a ground.
Because I am not fighting on the formula.
He was
I am fighting on a
advocate when the Millard this order was passed. Then Millard in the appeal court he became the AG, so he was not there.
ECL has approved the. So accord. Oh.
পাঠা কি পাঠিয়েছে আমায় দিয়ে দিস
if required,
according to you, this was approved.
Yes.
But the judgment records that this was not approved.
To higher authority.
Dear lordship, may kindly
records are subject and there is no novation.
Yes.
The contract has to be novated unless
even a letter was issued indicates the modified clause would come into effect from the date of issue. Has approved the substitution, but it would be apparent and evident from the subsequent letter dated 14th of June that it was so approved subject to further orders. So, so really what went is the letter dated 14th of June. That's the subsequent one. Where is 14th of
Page 67. Page 67 of the SLP.
Lordship will find at page
67 of the SLP.
Page 67 of this SLP branch we have.
Yes. Page 67 of SLP.
So,
but for your lordship's similar convenience.
Yes. So it was a conditional one. In the general and additional terms of the bid document would come into effect from the date of issue of the office order by ECL regarding modification. Where is this office order? Subsequent.
SLP.
Millard, 14th of June, Millard, again, Millard, this is the confusion. 14th of June relates to the formula. We are not fighting on the formula. But if your lordship may kindly have a look to Millard, this 14th June letter.
The rate Millard, the stay application is.
Millard, in a 14th June letter, please take paragraph number 1.
Yes.
Incorporation of price variation of diesel escalation formula from transport chapter against the existing price variation of diesel escalation formula as followed in other subsidiaries and the provisions in the transport chapter of so and so. But we are not fighting on formula. We are not fighting on amendment to the formula. This is the error apparent. We are saying that the base rate should be given to me. Now, if your lordship may kindly take the next page, that is the last paragraph of 14 June letter. Board, after detailed deliberation, approved that in case of ongoing contracts and future tenders, the modification in the general additional terms and conditions of the bid document would come into effect from the date of issue of office order by ECL regarding modification inclusion of price variation clause for diesel. But I am not on formula. My case is not on amendment of formula. My case is that you have already taken a decision to give me escalation, please stick to that decision.
Mr. Datta, escalation would be on the basis of a formula.
A formula's application is not required.
Well, at page
No.
69, Lordship will.
That may not
Yes.
be. We take it that you are not challenging the formula.
No.
Now but the escalation is on the basis of some formula.
Yes.
Escalation is on the basis of some formula. So now the escalation, where is the decision taken by the authorities or from which date?
Page 180. Page 180. 180
of the
of FMA.
Page 69, Lordship takes the SLP, it will be clear. It's part of his SLP, I'm Millard. Now, Millard, page 69. Lordship sees.
এই কোনটা দেখাচ্ছিস তুই?
69, তোমার SLP.
Is 180
is to confusion. Please take me to page 180 of the FMA.
FMA, yes, FMA
Now,
is here.
but this is 14th of March again, 2013.
14th of March.
Yes. Now, please see, reproduced below is the relevant extract of the minutes of the meeting of the functional directors of ECL held on 20th of March 2013 at so-and-so place with regard to the table under item serial number 3 and 4. Serial number 3 was approval of considering base rate of HSD on industrial price and considered the monthly diesel escalation bill.
So according to you, this is the final decision.
Yes, in my favor.
So
I am not
according to you, there
concerned.
is nothing more to be taken.
Right.
No
Now-
further approval or decision to be taken.
Yes. Now, what is the cause of action? The cause of action is that this is the functional director's decision.
Yes.
Now, Millard, the cause of action before your lordships was withdrawal of this, Millard, at page 184. This is the cause of action.
So this decision was withdrawn.
Yes. Therefore, I came to court. I am not fighting on any formula. Millard, at page 184.
This is not very
This is
late.
to inform, it's a bit, Millard, hazy. This is to inform you that the functional directors in the meeting on 18/11/2013, after detailed deliberation, approved the suspension of the earlier decision taken by the functional directors in the meeting of 20th of February 2013.
It's by a higher authority.
No,
They
according to
they suspend this decision of the functional directors.
yes.
It's an authority higher than the functional.
Millard, your lordship may decide that, but Millard, this did not fall for consideration.
And the clause was also not modified because it's a Millard contract.
I don't require modification of that clause.
The contract.
So that will satisfy the court.
Why is a question of review then, Millard? It's a question of appeal.
No, it's not a question of appeal. Millard, I say that I am not on formula. Yes.
Page 193, take his writ petition. Page 193 of Millard, the paper book. Or Millard, his case is kindly take in the matter of the purported action on the part of the respondent in not allowing the petitioner to stop work for escalation of overburden for allowing price escalation on irrational and untenable grounds. Everything is on price escalation.
Yes. Not applying any formula.
The doctor says that he is not on the formula. According to him, there was a decision taken in his favor that he will be entitled to price escalation, whatever may be the formula.
Absolutely.
So thereafter, subsequently, that decision was taken by the functional director.
Right.
No, subsequently by a higher authority, that decision was suspended.
That is recorded in your lordship's order.
Yes, so that was suspended. His cause of action for the writ petition was that suspension.
Right.
Suspension of that decision of the higher authority.
Yes.
The writ court was in Mr. Datta's favor.
Correct.
So in the appeal, so that was
Turned
reversed.
down, my lord, with reasons on novation.
He
and
says,
everything.
yes,
Kindly have a look at lordship's order. Lordship has given a detailed order finding on it.
Finding is on the amendment of the formula.
Kindly, my
Whether
lord,
the formula has
it may
been
be a bad
amended or
order. It may be a bad order. It may be.
No. I don't.
Millard kindly takes Millard the formula in question. Kindly have a look at it. It's my lord's order.
Millard, I am not on formula. Why is my learned friend
I do not
referring
know
to the
what is-
formula?
I do not want. I am only on page 2.
I am on the price.
Kindly take Millard. Kindly take what lordships had decided at page 242.
Page. Internal
Page
page number.
242. What Millard?
Page
Of
42
or Millard kindly
of
take
its
the
SLP.
Oh no, kindly take Millard the main matter, Millard.
Yes.
Kindly have a look at the review petition. Any one of them will do.
Yes.
Kindly have a look at paragraph, page number 21.
Internal.
Yes.
Internal page 21. It is not in dispute that the base rate of payment under escalation formula was made operative from 7/1/2009, which was evident from the work order issued to the respondent number 1 on 4/2/2010. Subsequently, an arrangement was made with IOC when HSD was supplied to the respondent as a bulk consumer as the retail rate. Undoubtedly, the government gives subsidy to the retail consumer, and therefore the price is less than the price of diesel if sold to the bulk consumer. There is no dispute in charging of the price of diesel as per the arrangement with IOC, but despite dispute arose when IOC rescinded the bulk arrangement and decided to sell HSD to bulk consumer at a rate applicable thereto. The price of diesel cannot be interpreted to mean the base price. So, that is the finding of the division bench. Base price to the subsidy and other components inbuilt in it. The price in ordinary parlance means price at which the seller sells the good and the purchaser purchases it. It's Lordship's interpretation. The subsidy is an integral part of the price and cannot be segregated therefrom so as to become a standalone component. It is the policy of the government to give subsidy to the public sector who buys diesel for personal use. However, the government does not propose to give incentive in form of subsidy to the bulk consumers who are using the same for the purpose. The contention of Mr. Such and such a subsidy can never be formed part of the price is not acceptable if a component cannot be segregated, dissected or taken up from the final price by the seller. It remains an integral part of the price. We do not find any difficulty in finding out the reasons of the price, the HSD for applying the escalation.
I am not on formula.
We per poise. So, it says, the base price is part of what he is getting. That is what the saying, this is cannot be read with.
But I am not on the application of any formula.
The question is,
this is the error.
Look, that is contained in the formula as varied or modified. The respondent number 1 approach for withdrawal of the arrangement. This is most important. Kindly read on. The respondent approached the ACL appellant after withdrawal of the arrangement and necessary to increase the price of diesel and failed to take a decision thereon that the order to avoid prolixity and confusion and or ambiguity, such escalation formula needs be modification.
Yes.
Though the approval was made, but it is sufficient to the modification to be incorporated in the general terms. The resolution says, board after detailed delivery approving and the ongoing future tenderers, the modification of the general and the additional terms of the bid would come into effect from the date of issue of the office order of ECL regarding modification, inclusion of inclusion of price variation clause of diesel, de-escalation, performance security, medical treatment of the contractor in line. What can be seen from the said resolution is that although the modification was approved, but it was to take effect from the date of issue of the office order of the ECL. By a letter dated 20th March 2023, the General Manager MC simply recorded approval of the modification to be incorporated in the general terms of condition.
But I am not on any modification.
My
case is not on track. Why is my learned friend relying on this? This is error.
GCC. One has to fall back on the GCC. He refers on a letter formula the base price of the diesel. This is what weight and detailed reasons have been given by your lordship. Where it's the question, it may be a good order, it may be a bad order. Well, I may be aggrieved. There are recourses open. Is it a ground for review? Well, I argue X, court goes on a premise Y. It may be a ground for very good ground for setting aside the order. It's a ground for review. Unfortunately, it's not. Where I am fortified with the authorities, lordship will hear.
59.
For review, it's not. It may be a very good ground for appeal.
The error apparent is that the discussion on formula was not the case built up before the court.
Where is the writ petition?
Yes. Now, please have a look at my prayers in the writ petition. Will your lordship find it at page 73?
73 of the SLP. Of the SLP.
No, FMA.
FMA আছে
FMA ফাইলটা কোথাও আনিয়ে নিন তো, নাহলে তো মুশকিল হবে।
Price escalation.
I think Mr. Doctor, those FMA file is to be brought. But FMA
Page
file
73 Miller, prayer B Miller. I would have placed it. টুডে থিং আজকে আর হবে না স্যার।
ঠিক আছে,
করো না 14 তারিখ বাদ দিয়ে করো আজ 9:30।
He wants it on another
No,
day.
I don't want. I am ready, Miller. I think it's 3:30.
Just I'll place the prayers, Miller, just for your lordship's consideration. ওটা কি স্পাইরালটা কি?
আচ্ছা ওটা বোধহয় listen to. Yes,
Kindly see my prayer B at page 73. Mandamus directing so and so to forthwith grant disburse additional payment to the petitioner pertaining to price escalation caused due to constraint of purchasing the bulk high-speed diesel to enable the petitioner to conclude the balance tender. But I have not asked for any
Consequential.
Yes,
C is consequential.
C is consequential. I am not saying that you amend the formula or apply the formula.
Millard, it's on the question of bulk rate.
Yes.
Millard, there is
Rate accepted. Millard, my cause of action is you have accepted my prayer. Now you have gone back on that acceptance.
Millard, there's a by way of a letter, can a term of a contract be amended?
That's a different thing. That
That's section for 62 of the Contract Act, novation. Where is that is exactly Lordship sir.
Incorporation, Mr. Datta, has to be made.
No, Millard, this
There
is
is
what
no
Millard,
incorporation.
I am unable to, Millard, convince the court. I'm sorry, Millard. I am not saying that apply formula A, B, and C. I am saying that since the price of diesel have escalated from X date, you give me the benefit of price escalation from X date.
Oh, yes,
correct.
Number one, may only complete, Millard. This was accepted. I was very happy because it has been accepted from the date of escalation. Subsequently, that decision has been suspended. That is the cause of action. Now, your lordships have to decide whether that suspension is right or wrong. No formula is required to be applied.
Accepted. But when, let us fall back on the first thing, when the decision was taken that your contention is accepted.
Yes.
Now, is it not required to be incorporated in the contract?
No, not required. Because the contract clause is there. I will not invite the court, nor was any submission made that the contract clause required an amendment.
But the decision is to that effect. Because,
yes, this is the confusion, Millard. There were two decisions on two different aspects on the same day. That is the error.
The other letter is not subject to correction, not part of the,
yes.
How it came and this was this.
That Millard, none of us.
Millard, there is a contract.
Somebody told me, Millard,
now,
not
Millard,
to be taken on record, that while arguing, one of the counsels had handed up the other letter to the court.
Millard, there is a contract.
That is why it has come in the judgment. Otherwise, if it is not on record, obviously it cannot come in the
He's
judgment.
correct in that there is a formula. That formula has a Millard base rate of diesel that is Millard fixed. Now Millard, he doesn't want the market rate, he wants some other rate to put in. So formula anyway has to be. But this cannot be my first argument, ground for review. It may be a erroneous
Fix
decision.
another date when file gulo aniye nebe to. What date? Brother was suggesting the Saturday.
Shonivar,
that is why I asked my brother.
Well, keep it with subject to your lordship's business.
Friday, but only difficulty is that my brother has to take. It would be might be a tentative date. Give your convenient date.
14th is a deemed Friday.
Kindly do not keep it on.
Very well, sure. 8th in that case.
8th.
8th of August.
Yes, ma'am.
No date.
Well, it can be on the 1st of August also, if the business of the court permits.
I think let us keep it on 8th, but it will be a tentative because.
Lakshmi আসছে না
After that, so let us keep it at
Yes,
3
yes.
so
We'll
that
continue and finish it.
Very good.
I think otherwise this,
No. But I won't take more than maximum half an hour. Well, only to clarify all this confusion. First, I need to clear the confusion.
but
Because
only
two
one thing, the other document.
may I file a supplementary affidavit bringing them on record?
Or the SLP can be on record. That will be easy. If the
Secondly,
SLP,
all the documents are there.
I'll go through it. Well, I believe so.
SLP the shop document. Sure. It's there, but I'm told it's there. All documents are there. I'll please. SLP have taken it.
I'll see the SLP lordship and call for the records. I think records.
So that is, I've directed the records of the FMA.
That
to
letter is not there. Two other
Okay,
documents are not.
Lordship will not find those.
If something is not there and lordship has passed an order, what is the consequence? Lordship has also.
Now the difficulty is, Mr. Ghosh, if it was the other way around, you could have said that. But Mr. Datta is suggesting what is on record, that was not considered. But what is not perhaps appearing in that stay application was considered.
Yes.
According to him, though he did not want it to be submitted, said that must be something some of the advocates have placed that, but it was considered. If it was the other way around,
I think it's the other. Willard, what document?
it was the document which was there was considered, but the document which Mr. Datta is now trying to rely upon was not there. It would have been a other way around. But Mr. Datta is saying other thing.
His Willard document is whatever is on record, lordship has, because annexure number is given below.
Yes, he says that was not considered, what was there, and a different thing which was not on record.
Had the same date.
Because that's the same date, because must be Mr. Ghosh, must be somewhat, because there is an existence of that document. It's not there because you can also verify that whether that document was there or not. So it's not in dispute that of the existence of that document. So unless it was produced by one of the parties, could not have been referred to in the judgment.
Right.
So that's what Mr. Datta's submission is. So perhaps some of any of the parties must have produced that document. And according to Mr. Datta, that was relied upon, but the document which was in the record was not relied upon.
That is his contention, because
that is his contention, and he wants to rely upon the one which is on record.
Right.
So according to him, even if you disregard that, according to him, this is an error apparent, non-consideration of a material which was on record.
Yes, lordship will consider that, whether lordship has considered on anything.
That is a decision.
If lordship has considered that document also, everything goes.
Yes, so that's a different thing. That's on merits we have to consider, but he wants to cite, but he wants to rely upon that. So you also check up that document. Mr. Datta, can you give those two letters to Mr. Ghosh? That's
We have
SLP.
given him the SLP. We have provided him with the SLP.
So you filed 2 copies of those SLP. এটা ফেরত SLP টা ফেরত দিয়ে দিয়েছেন SLP এটাও দিয়ে দিন, এটাও ওনারা লার্নেড আরো yes
Distribution bench item number 4.
Great.
4 last occasion, my lord, I appear for the review applicant. Last occasion, my lord, we had learned that the respondent number 7 had passed away. The respondent number 7 is a private respondent. He has died during the pendency of this application. We've taken out a CAN application, my lord, for substitution that is not appearing in the list. My lord, I can mention it's being taken out already, my lord. It's CAN 3 of 2025.
my lord, may that be listed, my lord can dispose of the application thereafter.
Application has not been listed.
It's not listed, my lord, it's been taken out today, my lord, today it has been filed, I must be candid, today itself it
Why
has,
today?
today, my lord. As well, my lord, but I have the filing number, my lord, the acknowledgement receipt is there.
এত খুব আবসা উঠেছে কেন কিছু বোঝা যাচ্ছে না।
That's for substitution, my lord.
The learned advocate and 3টায় হয়ে গেল। This next
Item number 5, I'm for the petition. I'm for the petitioner. The rule has been issued. The rule has been issued against the alleged contaminant, and no till now didn't appear.
Now it's 3:30. What can be done? The time is over. Rule has been served.
Rule has been served. Yes.
দিনে ছিল না এটা কি হলো? 24th of June.
24th June.
Why? Permission তো হয়েছে। 27 তারিখে ছিল না এখন ছিল 27 তারিখ পরের দিনই you are appealing for the contemner.
See, item number 5. Item number 5, yes.
Yes.
No, no, it's okay. It is a division bench matter. It's okay. No, no,
So you are for the single bench.
single bench. No, no, no.
Yes.
Then liberty may please be given to file the contempt application before the single bench.
By this application Yes.
Item number 6. Lordship, I'm a doctor by profession. I'm a doctor by profession, and I'm just in person. I've moved a review petition in person.
Yes.
But the problem is that I have not served the opposite party any notice because I was told that there will be admission hearing first, and thereafter, if it is admitted, then only copies can be served to others.
Yes.
The issue is that it is a question of a medical murder of my only child, a 32-year-old daughter, and the reasons and the causes what were given
So
by
that permitted you to file a complaint before the commission.
Yeah. Yes, my lord.
So how, where is the error apparent in this? Have you filed the application complaint before the commission?
No.
Why?
No, because this judgment, what has been passed by this honorable, appeal court, is completely based on a different issue, my lord. My lord, I challenged an order of the commission dated 24th of May 2024, and the honorable appeal court has given a complete judgment on an order of the West Bengal Clinical Establishment Commission dated 30/1/2023, one year 4 months prior. So this is a completely different. The complete judgment is based on an erroneous reference of the order. I challenged 24/5/2024, but the judgment has been passed on 30/1/2023. That means a complete erroneous reference to the actual challenge. I challenged with
No,
some.
you challenged which order? You challenged August 8, 2024.
Yes, that is the writ
That was
petition.
considered.
That is writ petition. But the writ petition made a mistake that it did not consider the causes of action and the order of the.
No, if this order proceeds on an erroneous basis, you can prefer an appeal against this. Review is not maintainable. Prefer an appeal against this.
Where? Supreme Court.
Because appeal, you have it has been decided one way or the other against the and we have given you liberty to prefer a complaint before the commission.
But the commission is not considering what I am saying.
Pursuant to this, have you filed a complaint?
No.
If according to you there is any error in the judgment, then you can prefer an appeal. Ashun, heard the learned Yes. Disposed of. Yes. আর নেই তো?
My honor, shall be permitted to mention one thing. In single bench matter can be upgraded
Division
to 2
bench.
PM.
এইটা না, এই দুটো ওই যেটা এই দুটো বই একটু দিয়ে দেবেন তো, ট্রাইব্যুনাল রুলসটা একটু পাঠিয়ে দেবেন আমার।